I hereby call this special magistrate proceeding to order. It is 9:10 on Tuesday, May 23, 2023. My name is Robert Riggio. I will be the special magistrate hearing the matters this morning. And for the most part, they will be heard along the order that is in the agenda. I believe the agenda is posted over there, so you'll see where your case, but we have a fairly brief agenda, and so cases probably will be heard in fairly short order. The general procedure for this proceeding is I will call a case, ask that at that point that if you are here, please come forward. At that point, please state your name and address, and Mr. Bagazzoli will, did I pronounce that right?
You did.
Will then swear you in because sworn testimony is provided in this proceeding. And at that point, the matter will be turned over to the city inspector, who will then provide the details of what it is that is being alleged against you, and then you will be given an opportunity to state your rebuttals or your whatever you want to do and state in your defense. And then I will consider what has been stated and render my judgment regarding these items. I will issue an order. That order will then be placed in writing and it'll be sent to you. And from there, you can take it, do what you want to do. But there are several different types of orders that are issued. I think a few of you here are simply here on compliance issues. If you are found in non-compliance, you'll typically be given 30 days in which to bring it into compliance, at which time you need to get with the inspector, because the inspector is the one who makes a determination as to whether or not you are in compliance or not. If the inspector finds you in compliance, the matter's closed. If you are not found in compliance by the date that is provided for, you will then have to come back to another hearing where you may either ask for more time, state that there are extenuating circumstances as to why you cannot get the bring the property into compliance, or in some cases a fine will be levied at that point. And it will usually be a per diem fine, which means that if it's $50 a day, the faster you get it done, the less the fine is. But again, when you do, if you make corrections or feel you have the property into compliance, it's incumbent upon you to get with the inspector who makes that final determination. Generally speaking, on issues that relate to the condition of the property, I don't make those types of determinations. I rely heavily on what the inspectors have to say and on the photographs that are provided and things of that sort. Okay, the next item on the agenda are announcements. Do we have any announcements?
There's two matters to bring to your attention. On page 2, case 1, RTL 05-2339 is now in compliance.
Okay.
On page 5, case 12, RTL 05-2338, we have received an email communication from the owner asking to move the hearing date to June 27th, 2023 due to urgent medical matters. Okay.
And when we get to that one, I will continue that case. I have no problem with that. Okay. I have approved the minutes of the April 25th, 2023 meeting and provided them to the city. The next item, it's a little bit out of order. Are there any attorneys present here today? Okay. Ms. Gow, are you here on behalf of Advanced Minerals? Okay. We'll take you out of order so we can get you out of here.
Yeah, we have to swear in the staff.
That's true. Could you, at this point, will members of the staff, please, city employees and staff, please come forward, or going to give testimony and be sworn in?
do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Okay. We're going to go to case number 2, RTL 04-22-106, Advanced Minerals, Inc., trustee and 317 Fairview Avenue Land Trust, cited for failure to correct violations of city code at 317 Fairview Avenue. Mr. Mango, do you want to give sort of a brief introduction? And I expect Ms. Gow will probably ask for some additional time. So if you could do that right now.
Okay. I'm Inspector LaWanda Tomingo with City of Daytona Beach Code Compliance. My credentials are on file with the city. Since the last hearing, I have received email communication from Mrs. Gow that the building in the rear of the property has been demolished. There is still the matter of the change in the land use that is going to be going before the planning board next month, is what I've been informed by Attorney Gow. So I am requesting to amend to next cutoff to allow time for that process.
Okay. When does planning board meet?
It was rescheduled to,
For the record, Jessica Gow, Cobb Cole, 149 South Ridgewood Avenue, Daytona Beach, Florida. The May planning board is where we thought this item would be. That was supposed to be this Thursday. And so we thought the agenda would be out and we could see it. That had a lack of a quorum, so it's been rescheduled to June 1st.
Okay.
The normal June planning board is June 22nd. And so I have the agenda until it comes out. But the June 1st agenda will be out next Friday. If it's on there, I'll share it with the city. It does have to go to planning board and 2 readings before city commission. So I'm happy to come back and give an update on the planning board hearing.
Okay. If you're happy to come back, we'll certainly accommodate you and allow you to come back. So therefore, we will amend this to the June, the June cutoff, the June meeting date is the 27th.
Perfect.
Okay. Therefore, in case number 2, RTL 04-22-106, Advanced Minerals, Inc., trustee and 317 Fairview Avenue Land Trust for property at 317 Fairview Avenue, I hereby order the previous order of noncompliance be amended to allow the respondent until June 21st, 2023 to bring the property into compliance or be returned to a proceeding. Well, it's an amend. I'm just going to do a continuance because we're not really talking about compliance, non-compliance, because you still have to go, depending on whatever the outcome is, of planning board before city commission.
Right.
And if the planning board doesn't approve it, city commission still can, so you could still be in compliance. So therefore, with respect to case number 2, RTL 04-22-106, Advanced Minerals, Inc., trustee and 317 Fairview Avenue Land Trust for property at 317 Fairview Avenue, I hereby order that this matter be continued until the June 27, 2023 special magistrate proceeding.
Perfect. Thank you.
And hopefully you'll get a positive response on your request.
It's the city request, so they're running it administratively, so I hope you guys, but yes.
Okay.
Thank you.
All right, we're going to go back to the items as they are on the agenda, with the first item being a lien review. Lien Review 1, CEB 03-2058, 748 Owasso Street, Nathan Blankenship. Property is at 748 Owasso Street. Mr. Reconcile? Oh, do we have someone present on behalf of the respondent in this matter?
Nathan, can you raise your right hand?
Yes, sir.
Please state your name.
Nathan Blankenship.
Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
Okay, Mr. Reckenzone, can you provide us with a recap of what's been discussed in this matter so far and where we stand?
This is a lien review.
Yes.
The property and the city has had a meeting before the hearing, and we have agreed to a $1,500 reduction to 15.
Okay. All right. Mr. Blankenship, from the materials that I have, I see an email from you saying that that's agreeable to you? Is that
Yes,
correct?
sir. Yes, sir.
Then it's agreeable to me. And I'll keep this short. So therefore, in CEB 03-2058, respondent being Nathan Blankenship for property at 748 Owasso Street, I hereby order the lien in that case to be reduced to the amount of $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. So, Mr. Blankenship, you understand that. You have 30 days in which to pay it.
Yes, sir.
And I always add this caveat at the end. If something unexpected comes up that prevents that, please get with the city attorney's office or Mr. Reckenzone to explain what is the problem, if there is one.
Yes, sir.
And then something can hopefully be worked out.
I'll get it paid right away. Thank you, sir.
Okay. Thank you.
Thank you.
All right. Next item, CEB 08-21-183, lien review 2 for property at 433 Pelican Bay Drive, Harpreet Kaur Sadhi and Harbans Kalra. Good morning.
Good morning, Your Honor. My name is Jasprit Sodhi. I'm on behalf of Harpreet Sodhi for 433 Pelican Bay Drive, Daytona Beach.
Okay.
Please
We will
raise
need
your
to
right-
have you sworn in.
Sorry.
No,
Please-
Your Honor.
Please raise your right hand. Do you solemnly swear, pardon me, you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I swear.
And can you please spell your name?
Jasereet, last name Sodhi, Sodhi.
Thank you.
Okay.
In this relationship,
Sir, what is your relationship to the two respondents?
I'm the brother to Harpreet Sodhi, and Harbans Kalra is my uncle.
Okay. And are you authorized to speak on their behalf?
Yes, I am, Your Honor.
Okay. Okay, Ms. Domingo, can you provide me with some recap of where things stand on this one?
Yes, this is a case that was opened August 31st of 2020 as an unlicensed rental property. The owner was first notified by posting on March 2nd of 2021 due to the original first notice being returned. And just for record, the owners for the property do live out of this country, so that, you know, may have something to do with the lapse of time for that mail to be returned. The compliance date was March 16th of 2021. We did a rental inspection April 8th of 2021 with failed results. There was a second failed inspection November 10th of 2021. The property did not come into compliance until June 27th of 2022. And we received the lien review request, and we did meet by Zoom with Mr. Sodhi here, and we're not able to come to an agreement. I am recommending no reduction in the lien fine, just due to the two failed inspection. I do have correspondence by email from Mr. Sodhi regarding requesting a re-inspection a second time for November 10th with documentation that stating that all the repairs were made. However, when I went out to the property, there was still the matter of a stove that was in disrepair and screens on the second floor windows that were not installed, to which we did also have a discussion by phone on November 18th where it was relayed to me by Mr. Sodi that there was an issue with the stove repair because of not wanting to alter a marble slab that was contained around the stove, and the property did not come into compliance until June 27th of 2022, the following year.
Okay. So the order was issued in November, as I recall. Would that have been like November 30th, the fine order?
Yes, sir.
November 23rd?
November
23rd.
23rd?
No, it's the meeting date, yes.
Okay. And so we are going from end of November until, you said June 27th?
June 27th of 2022.
Okay, that's roughly about 7 months.
Yes.
And really the main issues here were a stove and some screens that needed to be, if I recall.
Yes, there were window screens on the second floor for the master bedroom, the 2 additional bedrooms, a bathroom window, and a sliding screen door on the first level office sliding door, and again, a burner on the stove, which I did observe at that second reinspection on November 10th was still not working or in good repair.
Okay.
And I did have a detailed discussion with Mr. Jaspreet Sodi on November 18th, where we discussed those items that caused that inspection to fail again. And he informed me that the owner did not want to make the repairs to the stove due to additional modifications that would have to be made to the marble countertop in the kitchen. And he also informed me that he had listed the property for sale and was not going to rent it anymore after January the following year. I informed him at that time that did not, putting the property up for sale did not remedy the case because the property was in fact still being rented and tenant occupied, and that they would need to comply with making the repairs to the screens and to the stove. That's a phone call, November 18th, 2022 with Mr. Jaspreet Sodi that I have copied from the chronology notes in our case.
Okay. And the stove wasn't considered to be repaired until your inspection of June 27th?
Yes, sir.
Okay, and the screens weren't up until June 27th?
Yes, sir. I inspected both of those items, the multiple screens and the stove when I returned on June 27th, and they were in compliance at that juncture.
Okay. Mr. Sodi, what is your response to what Ms. Tomengo has informed me?
Your Honor, I would like to address, first of all, the items that were originally in non-compliance, which were safety related, the GFC switches, a couple of fan controllers missing, a couple of other items, which were addressed immediately when they were pointed out to us. That was in May 2021. After that, the screening part which was left over, we had contracted a company for replacing the screening in the pool area and the windows area in April 2021, which the contractor informed us that it'll take them a couple of months to get out there due to a lack of labor force and multiple appointments that they had, which they completed in September 2021. Once the screening were done, that's including the screening for the second floor, which were missing, were also replaced in September by the same contractors. And the stove burner in October was informed to us by our technician that went out there that he's temporarily got the stove working, but it needs to be replaced because the coils on those electric stove are not good and basically in good condition. They're old. So taking that review from the technician and the tenants at that point in the property, I had the call with Mr. Mango on November 18th with the discussion after I had with the owners regarding what they want to do in the next step because inspection has failed again and the stove is still not working when the inspection happened itself. And the screenings were not there. But before to that inspection in November, we were assured that the screenings are there and the stove is working by the tenant and the contractor that went out there. But apparently when the inspection happened, those two items were not working. After having that conversation on November 18th with Mr. Mango regarding selling the property and not renting out the property again and basically cashing out our investment, we made that decision upon all the comments, the information I had from the tenant without being in the country, without having an agent over there. And that was our mistake. We were relying on a party which was not exactly on our side. And the tenant was manipulating the compliance issues with the city so they could get a deal on the rent. And also they had an interest for purchasing the property so they could get a deal on the property stating, oh, you have compliance issues with the city, there's property problems, give us a deal. We refused to give them a deal. Therefore, their contract was over in January 2022, but they refused to move out. We were aiming that when November, the fine started, that at the moment they move out in January 1st, we would move in there and get those problems resolved immediately. That did not happen to plan because they decided to overstay until August 2022. It took us a very long time just to get those two things addressed and corrected, the stove and the screening and the upstairs windows. The reason for the screening was they were being removed by the tenant and their children upstairs for God knows what reason. The stove, the coil in the there's 3 burners on the stove, 4 burners. 3 were working perfectly, 1 large one was not working perfectly. The main reason what we discovered when my father got to the country on June 5th, 2022, personally, to check up on what's going on because we were really confused over a stove. He found out that the coils were put into the stove the opposite way around, which would not let that one coil light up instantly. Right now, as it states, that property still has that stove. That stove is working perfectly fine. It was just being defected by the tenant so they could manipulate us into giving them a deal because the property was under non-compliance. They also spoke to us about giving them a lease for a couple of years without the city knowing, without having rental licenses, without anything, so we can break out the city's formality, which we refuse to do. Because I have had properties previously in Daytona Beach, and I've always wanted to make sure they were all licensed and legally done. Because I have had trouble before, and I know that what is right and what needs to be done by the court enforcement. But the problem was not having the right access to the property by the tenant, being refused to access the property by the tenant to our contractors during the period of November all the way till June. Therefore, my father had to travel all the way from India to Florida to resolve this issue. We also had a barrier in our way, which was the COVID restrictions for travel. I understand that the Florida state was open under COVID restrictions, but restrictions from traveling out of India were only essential travel, and this travel was not deemed essential by the Indian government for my father to travel out until May 2022. And the moment those travel bans were lifted, he was one of the first ones out of there on a flight to Florida to resolve this matter.
Mr. Sadi, you understand that this was in November of 2021, a
That's right.
$100 a day fine was imposed on this property.
That
So
is right.
essentially, everything that transpired after May of 2022 is sort of irrelevant. The 15,000 had already accumulated as part of the fine.
That is right, Your Honor. From November 2021 all the way till June 2022, we did our full attempt to get the tenants out of the property so we could get in the property. They made excuses in January all the way to February for a couple of months that their daughter is ill, she has COVID, so they will not allow anyone into the property. They made multiple excuses. We had multiple trouble with the Pelican Bay Association regarding those tenants, multiple complaints from the neighbors. There was a lot of other business activities going on at the property by those same tenants. There were multiple factors which we were trying to remedy at the same time without being able to be in the country. We tried to hire agents for that purpose as well, but few of the agents were trying to just get our property sold or trying to get us into a legal battle with them, which would have taken even more longer, and it would have been a continuous event of just back and forth. We tried to negotiate with the tenant. I literally had communication back and forth with the tenant from November all the way till June, just regarding getting a couple of resolutions on the compliance issue for the city. I even gave them months of rent-free time so they could at least just get the city issues in compliance. It was a very minor issue, Your Honor. It was just a stove and a couple of screening. We had the whole pool screening enclosure replaced. It cost us thousands of dollars. But the one very small thing, which is not exactly a very expensive thing, they held us back for, and basically we were held hostage not to repair that so we could be in non-compliance with the city.
Okay. Mr. Sadi, do you have any kind of evidence, writings, anything to corroborate this story? Because what your request boils down to is that you're blaming someone who was not here that we don't know, and we have no evidence before us right now to support that claim.
I have multiple notices that I had sent out to the tenant on a weekly basis. I have multiple communications via email with the tenant requesting them for help and a remedy in this resolution, which I can share with the court, not a problem. I have everything on record with the tenant. I also communicated this part briefly in June with the code enforcement officer. And I also advised the code officer in June that when they contact us for the inspection, they'd contact us directly and not the tenant, because Ms. Tomago did contact the tenant in June, and the tenant advised them even in June, before the inspection in June, that, hey, it's still not fixed, nothing is done, the screenings are not there, stove is not done. But yet I reassured Mr. Mango that it is done, my father is there, please do the inspection. And my father literally from June 6th all the way to June 27th had to go to the property every single day to make sure that those screenings remain on the window and the stove remains untouched.
Okay, Mr. Sadi, I'm going to kind of cut to the chase at this point. The burden is on you to convince me that you should receive a reduction based on what is essentially right now your story. Okay, you have nothing to no extrinsic evidence to corroborate. You may not know that that is something that you need to do, but I need to, if I'm going to make a reduction, I need something more than pointing the finger at someone else and saying they're at fault. Okay, and I think this is a kind of thing that would be best, and I'll ask Mr. Jackson, City Attorney, this, in terms of a continued discussion with Mr. Sadi, in terms of trying to provide something to corroborate this story. That is a problem I'm having right now. It's always easy to blame someone who's not here, and won't be here.
Excuse me, Mr. Riggio, I have the same problem. Anthony Jackson, attorney for the city. If I can briefly speak with Mr. Sykes and Ms. Riggio, what I've been advised is that staff has met with Mr. Justbreed, I think it is, I don't remember.
Yes,
Justbreed.
sir. That's right.
And Mr. Sadi, and they've heard the whole story and
Your Honor,
told them they
I'll
had
give-
the same similar problem of not having. So he could have brought whatever or provided all these things that he says he has. They don't believe it would affect or influence the city's position in terms of from a negotiating perspective. So we don't really see any real benefit in a continuance.
Okay. Well, I understand your story is essentially you have a tenant who was sabotaging your efforts to bring the property into compliance. And I mean, the write-up talked about technicians who went and things of that nature. And those are the kinds of things that if there was a statement from a technician that said, I went there and I had initially seen that something looked bad, but then I went back and found out that the tenant was or something had been jury-rigged to look bad. I mean, but I have nothing right now. I have absolutely nothing other than a statement that somebody else is responsible, but that somebody else, I have no idea why they're doing it or what they're doing it. And as far as I'm concerned at this point, since you've met with the city and the city has expressed the same problems, you've had an opportunity, as I understand it, to submit things to corroborate what you're asking for. You haven't done so. The only conclusion I can draw at this point is that you've been told what you need to do and you haven't done it. And unfortunately, I see no basis for any reduction of the lien. So,
Your Honor, if I could be given the last opportunity, I'm going to collect statements from the contractors that were there. I can give you letters that were posted with pictures on the doors of the tenant. I can get you violations from the HOA association, but those things I'll have to collect from the agencies and the authorities that were related and the technicians that were related. That is something that would take time
Mr.
from-
Sadi, what I'm going to do is dismiss your request without prejudice, which means that if you can dig up something and you can satisfy city staff that there is some, it warrants some consideration, then it can be done. But if you can't, then as things stand right now, I have nothing before me with which to grant you any relief on this lien. Do you understand? So I'm going to grant it without prejudice. That means the lien's still on the property.
Deny it without prejudice.
Or deny it deny it without prejudice. That means that if you can come up with something to satisfy, and they feel that it meets some minimum requirement for consideration, then it can be brought back before me, okay? Otherwise, the lien stands. So therefore, in lien review 2, CEB 0821-183, 433 Pelican Bay Drive, Harpreet Kaur Sadi and Harbins Kalra respondents for property at 433 Pelican Bay Drive. I hereby deny the lien request without prejudice. That's all I can do, sir.
Yes, Your Honor, I understand, that's fair. I will get out to all evidence and statements from the people who have visited the property in the last couple of years, explaining and backing what I'm saying.
Like I said, the burden lies with you to convince somebody who knows nothing other than what has transpired before me at one of these proceedings, that there should be some relief that is granted. Okay? Thank you.
Thank you, Your Honor.
The next case will be, let's see, case 1 is in compliance, case 2 has been continued. We are now into case number 3 on the agenda, RTL 042332, Kurt Irving Taylor and Stacy Taylor, cited for failure to correct violations of city code at 537 Pelican Bay Drive. Mr. Mango? Is anyone, is anyone here on behalf of the Taylors? Kurt Taylor or Stacy Taylor? Are they on Zoom? Okay.
Okay, since the last hearing, I did complete a scheduled rental inspection on April 28th with failed results. I have not received any communication from the owner regarding a request for reinspection or to give any progress on the repairs. There were life safety issues with there being smoke detectors missing from bedrooms downstairs, outside vicinity of bedroom downstairs, and smoke detectors upstairs at the outside vicinity of the bedroom. There is damaged and dilapidated fencing around the property. There's missing window screens throughout the property. There is the maintenance of the landscaping and lawn. There was a lot of tree debris and landscaping trash that was in the yard that was supposed to be removed from the property.
Mr. Mango, does it still look like the pictures?
If you, to my knowledge, when I went by yesterday, what I could see was just a small landscaping trash pile.
What about the fences that were?
I was not able to, because I didn't get called back for a reinspection, I was not able to go on site in the rear
Okay.
to see that, but I did see, if you zoom in on that picture, there's a pile of what looks like fencing material being collected there at the right of that. That could be what is them either, removing parts of the damaged fence, but again, I have not been called to go back for the reinspection to confirm, actually what processes are going on. There's some of the landscaping trash that was there.
Is this likely to be hurricane damage or
That
storm
was
damage?
what was originally advised throughout the course of the case. I did have communication with the owner back in October, and he was informed at that time that, the repairs would need to be made so that the property could pass the inspection. And again, that was what was still on site when I went out for the inspection, April 28th.
Okay.
So,
Or 5 or 6 months later.
yes, sir.
Yeah.
With, no response for, progress of repairs or request for reinspection. So no contact at all.
Okay.
So I'll be requesting a fine of $100 a day up to $15,000 or until the property is in compliance.
And starting today?
Yes, sir.
Okay. You said the smoke detectors, are they in the bedrooms or are they
Um, it-
outside the bedrooms that are missing?
There's a 10-year battery life smoke detector needed at the outside vicinity of the bedroom downstairs.
Okay.
10-year battery life smoke detector needed inside the other downstairs bedroom. So there's one bedroom downstairs that needs one inside. And then at the upstairs, there is a 10-year battery life smoke detector that's needed at the upstairs hallway vicinity outside of the bedrooms upstairs.
Those are building code requirements, aren't they?
Yes, sir.
Okay. All right. And they have not gotten in touch with you?
I haven't received any contact from them.
Therefore, in case number 3, RTL 04-2332, respondents being Kurt Irving Taylor and Stacy Taylor for property at 537 Pelican Bay Drive. I find that the respondents who were previously found in noncompliance remain in noncompliance and therefore order a fine in the amount of $100 per day to commence on May 23, 2023, and to continue each day thereafter until a fine has reached the amount of $15,000 or the property is brought into compliance. Okay, case number 5, RTL 04-2333, Infinite Home Solutions, LLC, cited for failure to correct violations of city code at 735 Marion Street. Is there anyone here on behalf of Infinite Home Solutions, LLC? Are they on Zoom or request to be on Zoom?
No.
No, okay. Then there's no respondent present. Have they been notified of this hearing since we're going to consider whether or not there should be a fine?
Yes.
Yes, they have been?
Yes, they have been.
Okay. Ms. Domingo?
Okay, since the last hearing, I have not received direct contact from the owner of the property. There was a rental license application submitted and received on May 10th. That's under review. A new development since our pre-meet is that I went out to this property yesterday and discovered that it's actually been condemned by the building department. So I'm going to request to amend this property to the next hearing to give them time to either remedy that building department condemned status or to determine from them if they actually plan on going forward with the rental license application that they submitted. I don't know whether it's occupied or vacant, but I do know now since yesterday that it's condemned. So
Okay.
requesting to amend to
All
next
right.
cutoff to follow up on.
Will you coordinate that with
I'm,
whoever handles the condemnation? Because if there are people in it,
I think because I have knowledge that there is also an existing code case on this property that has a lien fine that is running on it. And I don't know if through that code case, it's been determined that it's vacant or occupied either. But
okay.
I can look in the notes for that building department condemned.
But at this point, you don't know whether there's anybody
I don't know
occupying
the status of the occupancy, no.
it. Okay. Therefore, case number 5, RTL 04-2333, respondent being Infinite Home Solutions, LLC, for property at 735 Marion Street. I hereby order the previous order of noncompliance be amended to allow the respondent until June 21st, 2023, to bring the property into compliance or be returned to a proceeding before the special magistrate on June 27th, 2023 for consideration of a fine of up to $1,000 per day. And if it's condemned, that may resolve everything, but we'll see.
Thank you.
Case number 4, RTL 04-2331, Kathleen Hanna, cited for failure to correct violations of city code at 611 Winchester Street. Is anyone here on behalf of Kathleen Hanna? There is no respondent present. Mr. Bagazzoli, have they been notified of this
They
hearing?
have been notified.
Okay. Mr. Reckenzone?
Since the last hearing, I've had no contact with the property owner. I have talked to the tenants, and they're still living at the property, and there's been no progress on getting a rental license. The city is requesting a $100 a day fine up to $15,000.
Okay. And so there's people there and there's no response from them.
Correct.
I feel maybe 150 is more in order.
Okay.
We need to get these folks' attention. And if they're not, I mean, this sounds like it's something that can be easily resolved. They can get with you and start the process of getting a license.
Yes, sir.
And they're not even on that track at this point, so. And you would like that to be start today?
Yes, sir.
Okay. Therefore, case number 4, RTL 042331, Kathleen Hanna, being the respondent for property at 611 Winchester Street. I find the respondent was previously found in noncompliance, remains in noncompliance, and therefore order a fine in the amount of $150 per day to commence on May 23, 2023, and to continue each day thereafter until the fine has reached the amount of $15,000 or the property is brought into compliance. All right, we will now move on to the irreparable and irreversible matters. And the first one being case number 6, RTL 042326. Timothy Hoffman, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 2040 South Peninsula Drive. Is there anyone present on behalf of Mr. Hoffman? This is a continued matter from the last hearing date in April. Is Mr. Hoffman want to be available on Zoom? Not there. Okay. Mr. Yates.
All right, the case before you was a zoning violation. The case was opened as a citizen's complaint. The property is zoned SFR5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed March 15, 2023. The violator was first notified March 16, 2023. The property was not actively advertising of March 24, 2023. The daily posted rate was $178. There were 5 reviews displayed. The check-in and check-out time were 4 p.m. and 11 a.m. We had people on site claiming it was a short-term rental, March 15, 2023. This is the second short-term rental case at this address for this owner. The original case was RTL 022233, dated March 6, 2022. The actions of the owner are irreparable and irreversible in nature, and due to the fact that this is the second occurrence, the city is requesting a one-time fine of $15,000.
Okay. Before I go any further, Mr. Bagazzoli, has the respondent in this been notified of this hearing today?
Yes, they have.
Okay. Mr. Jackson, do you have anything you wish to present?
Yeah, there is additional information that I think should just be made known to the U.S. Magistrate as we proceed on this. I guess they made inquiry, and maybe one of its staff could speak to this, made that they've sold this and wanted the purchaser to be noticed for this proceeding, and I guess they indeed were noticed. If someone from staff can speak to that, any of y'all who have that information.
I was sworn in. I'm the rental coordinator. We received an email from the respondent's mother, who is a broker, stating that he had sold the property, and he, in fact, has sold the property. He asked for a continuance from the May hearing to the June hearing, and then sold it at the end of May. And so that email communication is in your book, as well as a copy of the deed.
Okay.
And I believe they had some mistaken beliefs that because he sold it, that he was no longer associated with with this case.
Right.
And that is not the position of the city.
And the fact that he doesn't own any other property in Volusia County.
Mr. Jackson, isn't there a proceeding provided for in, was it chapter 169?
It's in 162.06.
162.
Yes, in 162.06, in fact, that section ends after addressing the issue of someone who may transfer property and their obligations. It ends with the very last paragraph after subsection 5D with the statement, if the property is transferred before the hearing, the proceeding shall not be dismissed. We would give it a new owner, but the new owner shall be provided a reasonable period of time to correct the violation before the hearing is held. Now, in this situation, we have an irreversible violation where, at least our perspective, I guess the correction has been made. Is that correct? Do we feel that? What's our position regarding correction?
Let me
believe-
just ask Mr. Yates, essentially what I need is a timeline. Probably the first thing I need to know is the date on which the conveyance started or occurred.
Give me 1 second.
I think we have the deed, that would probably be from
Enzo should have that.
the deed.
And I thought I put a copy in here.
Yes, we have from warranty deed between Peter Joseph and Timothy Hoffman. So that's the deed from 2021, and we should have a later deed.
Yes, sir. We should have one in the case file. I will also point out that she mentioned in her email that she did not have any responsibility to notify the new owner.
No.
Okay, sorry, yes, okay, yeah. So it came into compliance on March 24th, 2023.
Well, at least that's when we stopped seeing advertising.
Yes, that's when the advertising stopped.
Okay.
And I asked that question as relates to the obligation of this new owner as well. So by the time the ownership changed, our records show that there has been
No more advertising.
no more advertising. Okay, so it's only the prior owner.
Correct,
Okay,
which all occurred before the transfer.
okay.
Okay, so we have a new owner, but we have unresolved code violations from the previous owner that we are dealing with.
That's correct.
And Mr. Yates, if you could run this through, typically there's the date that you observed, the date you notify
Yeah,
them, and the date.
The date that it was first observed was March 15th, 2023. The date they were first notified is March 16th, 2023. And the property was not actively advertising as of March 24th, 2023. I'd also like to make a small correction. I said that this was a citizen's complaint and this was field generated. I misspoke.
Okay. So sometime you notified them on the 16th, and by the 24th,
It was down.
it was down. Okay. And has there been anything subsequent to that?
No.
Okay. So essentially, at this point, it becomes a question of whether you wish to impose a fine or on this property that unfortunately is going to affect the new owner. And that's between the new owner and the old owner to work out. There is, as Mr. Jackson has stated, there's a proceeding, quite frankly, generally in any kind of real estate closing, the title agents typically check to see if there's code violations.
Yeah. And this express obligations in the statute for the seller to make all that known to the buyer, or this presumption of fraud. So that would be an issue between the buyer and the seller.
Yeah, that becomes, and they can resolve that, but somebody has to pay it.
And she claimed it was, the broker claimed it was a cash deal.
I don't care what kind of deal it
Yeah.
was, as long as they're under an obligation to disclose it. They didn't. And this is a matter that they need to resolve, but the order imposing the fine, which constitutes a lien, stays on here.
Right, but we would be requesting for it to be a lien against the original violator and against the property. So basically, the new buyer would have been buying into the circumstance, but nevertheless, it was remedied by the time the new buyer came in, but nevertheless, they're buying it with the pending lien and now what we desire to be an existing lien.
Okay, well, all right. Mr. Yates, it appears that the comment that you made about this, there being a previous, well, let me backtrack. That previous case was from
Last year, February.
February,
March, sorry. Last year, March.
last March.
Yes.
So Mr. Hoffman had violated it in the owner of the property, Mr. Hoffman, had violated the ordinance back in March of 2022,
Correct.
and then he had violated again in 2023.
Yes, sir.
Okay. So, and you're asking for the 15,000.
Yes.
Okay. I
Guess the only other thing would be addressing the the irreparable, irreversible position of the city.
Mr. Jackson,
Certainly. I ask if there's anyone on Zoom and everyone that's present in the room, if you're listening up and listening in, if you're here for short-term rental type violations, as it relates to the issue of irreparable and irreversible, from the city's perspective, the statute provides for findings of violations being irreparable or irreversible in nature as pursuant to Chapter 162. And these considerations or the basis for our request are as follows. The nature of the violations are that they are beneficial gain to the property owner, advertising the conduct that is prohibited by the code. The effects of holding out a property as vacation rental is irreversible. The property is advertised worldwide, marketing a destination that draws people from all over the world for principal special events such as Daytona 500 races, Bike Week, as well as spring break and the world's most famous beach all throughout our summer months. The properties are also marketed as a draw to nearby destinations such as Disney World and the Space Coast. Once the properties are advertised, they can never be unadvertised. The reality of the World Wide Web is that you cannot push advertisements back into the tube. Information that is posted today can be printed, forwarded, retweeted, and even copied and posted on other sites. And after being taken down from the primary source, it's still accessible and producing rental inquiries through repostings in other places. The information has long-range effect, luring patrons with contract to participate in unlawful stays in our city, and risk of poor health, poor safety, poor welfare due to unregulated or self-regulated vacation accommodations that patrons enter at their own risk. One single day of advertising could potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotels, motels, and lawful vacation rental that have gone through proper zoning regulation, proper inspection, proper licensing, proper insurance, and proper taxation required by law. The transit nature of the rentals limit the means of the enforcement typically to identifying advertisements. By the time code enforcement arrives to properties, the transient patrons typically are gone from the property, or they're claiming misleading relationships that are often contradicted by the advertised visitor comments. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against the lawful accommodations businesses and the lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods. They diverge from traditional and reliable residential norms. There's a demand from the business community to our commission, which has led to a request for a strong deterrent to those that are raking in profits, avoiding state and local taxes, avoiding zoning requirements, and regulatory controls. We've seen rentals go for as much as $1,000 a week, and we realize substantial fines are the only true detriment tool available. By the time we arrive and say stop, the beneficial gains are already realized by the landowner, the property owner. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a fine that these violations, the city requests that you find that these violations are irreparable or irreversible in nature. And specifically in this case, as we look at our request for a fine of the maximum of the $15,000, we look to the issues of egregiousness, and in all circumstances, we find these rental violations to be egregious because of the way in which they affect the business owners, the lawful short-term rental owners, as well as the unfair business competition that exists. We found them, and then in addition to looking at the egregiousness, we also look at the efforts of the respondent to come into compliance. In this situation, we have a respondent who, in fact, intentionally delayed to try and avoid the remedies and the requirements of law by passing it along to someone else. And ultimately, a respondent who had knowledge, having been found in violation before and knowing that this was prohibited by the code. And then the last, again, is the history of the respondent. In this situation, the history is clear. He had a prior violation. He's been found and put on notice that this is prohibited by our code, and nevertheless continued to conduct. Therefore, with all of those being considered, we ask for a finding of irreparable or reversible in nature and a fine of $15,000 for this violation.
Okay. Mr. Jackson, before you sit down, in going over the emails that I see in the case folder, I see a comment by the respondent to the effect that they weren't leasing the property, they just had it on Airbnb. What is the city's position regarding that?
Yeah, as I mentioned before, one of the most effective ways for us to be able to enforce this violation is by seeing the advertisements themselves. And the city has adopted the area of the statute as it relates specifically to guest rentals, which is what the guest rental is part of the definition of those that are doing short-term rental. And so with the adoption of that, it includes the state law that says that defines vacation rentals or guest rentals to include advertising for the transient guest. The transient guest meaning one that would be there short-term. And so we've adopted that from the state law, and that is what we utilize in finding someone in violation due to their advertising.
So the holding it out for rent is essentially the same as actually renting it.
That's correct. Been recognized that way through the legislature, the state law, and it's been recognized that way throughout since we've been enforcing it in our city.
Okay.
Turn it back up to the back.
And the other thing I'll point out specifically for this case is that we also have a lease that they've given us that shows that it's actually less than 6 months. So they provided a lease showing it's a short-term rental. And then we also have, if you'd like to view a video of someone on site saying that they rented it through Airbnb for a short-term rental. But you'll see It's March 1st, 2023 to May 31st, 2023, which is less than 6 months.
Okay.
Pretty much a 2-month lease.
Yes.
Okay.
So that would qualify as short term on its own.
So there's pretty much irrefutable
Provided by them, yes, sir.
evidence provided by them. Yep. Okay. Therefore, in case number 6, RTL 042326, I find the respondent, Timothy Hoffman, to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.A.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and a damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 2040 South Peninsula Drive, and to have subsequently come into compliance. Do we have a compliance date at this point?
Yes, 3/24/23.
And subsequently come into compliance on March 24th, 2023, and hereby order that respondent who has previously been found in violation of this ordinance shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again, and that for any future repeat violation of respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. All right. Case number 7, RTL 042330, Alan Lutens and Dolores Lutens, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.A, Article 5, Section 5.2.A.2, at 255 Lexington Drive. Is anyone here on behalf of Alan and Dolores Lutens? Sir, please come forward.
Please state your name.
Alan Luton.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I swear. Good morning. And first off, I'd like to thank you for extending from last month. I was supposed to be here last month. My business partner, who's supposed to be sitting next to me right now, is not here. That's why I asked for the continuance, so I'm sorry for that. I wanted to be here to be a part of, to be able to correct this. Do I need to, are you going to present the case or whatever?
Yes.
Thank you.
All right. The case before you is a zoning violation. The case was opened as a citizen's complaint. The property is zoned MFR 12. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed March 29, 2003. They were notified the same day. The property was not actively advertising as of April 3rd, 2023. The daily posted rate was $334. One review was displayed. The check-in and check-out times show as 4 p.m. and 11 a.m. We had people on site claiming to be a short-term rental March 29, 2023. These actions are irreparable and irreversible in nature, but due to the actions of the property owner, we're requesting a one-time fine of $1,000.
Okay. Mr. Jackson, do you have anything to present?
Yes, Heard my presentation a moment ago. That's something I can do again if you feel the need for me to do that again, or you can waive me reading it again, and we'll just ask the magistrate to incorporate it into the proceeding. And that would be just my position as relates to.
You put your position in, yeah, as long as I have a rebuttal, right?
Yes,
Oh,
would
you
have a
certainly have an
opportunity.
but
Yeah,
what
yeah,
Mr. Jackson gave a presentation why the city considers these violations
Yeah, I
to
heard
be
the other one was
irreparable and
a little bit,
irreversible.
Strong for me, but yeah, go ahead. I mean,
Okay, so if you don't have any objection to that, then, yeah, we'll
I have
ask.
objection,
ask
but
that-
so I have to say my.
No,
first.
I mean, you'll be able to
Yeah.
say your part, but I'm just
Thank you.
saying as far as for it being waiving me reading it again, if you don't have any problem with waiving me to read it again.
No, I don't have a problem with waiving.
Okay,
it.
and I incorporate that into the record. for his previous statements.
And of course, you'll have a right to respond
Yeah.
if you're elected, and I'd have a right to respond if
Yeah.
necessary, or any inquiries, any questions you have about what I
Correct.
had to say, I'll be happy to
Yeah.
address as well.
Okay. Therefore, I will incorporate Mr. Jackson's statements regarding these these alleged violations being irreparable and irreversible that were made in the previous case, case number 6 RTLO 42326, into this proceeding.
Okay.
And now, Mr. Lutens,
Yeah, thank you.
it is your opportunity to tell us your side of the story.
Perfect. Thank you. This house was purchased over 4 years ago. The bottom line, my mom was going to move into it. Things happen. Things changes. I obtained a long-term rental. The former person left. Mr. Reckenzone was the person that came out, and I did the changes to it. And we put over $12,000 into it. It's kind of funny to hear the other case where you're hearing here where the tenant wouldn't allow in and that stuff. I dealt with that, so I could understand his point, but we were able to prove that, and then we made changes. The bottom line is my business partner and other things I listen to quite frequently. I'll take full responsibility of it. His sister, did the advertising when I heard you do the other stuff and all that. I travel a lot. I'm out of town quite a bit. So he kind of handles this. He was looking for a way for me to be able to recoup the $12,000 that we put into it. I asked him to look into it, as far as if there's anything against it, because we have special zoning on the property, as far as for multiple families and whatever. So he said that there's nothing in the laws against it. And I said, are you sure about this? Now, Honor, this doesn't have anything really to do with it. I'm on the condemned board too, as far as that. I've took the ethics and all that. So I see that. I understand the point. I made a mistake, as far as trusting it. I take full responsibility. It's a first-time thing. What he told me is that immediately, he lives nearby there. There was a posting on the front door. I think he called because I was gone. He talked to Mr. Gates, or he tried to contact Mr. Gates a couple of times. Now, again, my business partner is kind of strong. If you look at him, he looks like a really innocent guy, but he talks very, rough on the phone, and he's kind of thing. He said that he had a hard time communicating with Mr. Gates, not with you, on you, but he was hard to get the information. That doesn't mean anything about it. But it was taken down. He contacted his sister, and we pulled it off the market. So involved with the assistant to the attorney in regard when he was talking about the long-term damage about all of this stuff. It's stuff, we stopped it, and there's not been anybody in there. And right now we're waiting for a long-term rental to go in there, but as you know, it's kind of difficult right now, especially since I've raised the price for all the changes. It's hard to get a rental in there. But again, that's it. I would ask, since it's the first time that you would waive that. It's not going to happen again, obviously. I'm aware of it. I wasn't aware. I trusted somebody else to make the right decision for me, but I'm still responsible for it. So that's what I'm asking.
Mr. Lutens, I hear what you have to say. You are not the first person to provide that presentation.
Right.
But we have I have found over the course of several years now that a fine is to be levied on, unfortunately, for first occurrences. We have lots of them, and it seems like everybody in the city is trying to figure out whether or not they can rent properties, because despite the fact this has been going on now for 3 years, I still have 7 matters today, and it's every month. One would think the word would get out, but for whatever reason. And the standard way of treating individuals in your situation has been, unfortunately for you, to levy a fine in the amount of $1,000. You're being treated no differently than anyone else in your circumstance. I
understand, Your Honor, as far as saying that. What I'd like to present to you as far as this, my partner's pretty sharp. And he said the law, as far as reading it, it's wishy-washy. It's not solid on definition. It can be read many different ways. That's what I went with, okay? And listening to your presentation earlier, and as far as the long-term effects, I'd just like to know for my own benefit. I understand that. I would like to look at, what am I looking at cited? Because I did not know what codes, whatever this is. He should have been here because he is the one that disseminated that. I would just like to know what I need to be looking at for future knowledge. Not that I'm going to do that. It's like anything. I'm kind of feeling that there's a gray area here. And yes, there's been standards set. I understand that as a first-time person. But I'd also like to learn, because I'm in a position later on, too, with what I'm dealing with, too, to do the right information and listen and give it a fair from both sides standpoints. That's all I'm asking is, if you could point that out to me.
Can you
Everything else.
go ahead and move the slide forward
Yeah.
to the zoning so he can just see it's very simple, very straightforward.
I want to point it to him.
Yeah. One more? Right there. If you see other accommodations, if you don't have an X there, you can't do it.
So where is that found on the table in there? Is that in
That's
zoning, in our zoning?
In the land development.
in
code.
development
Yes, sir.
5.2.A.2. Right there in black and white.
Then in
My
addition to that, just for your benefit. This is how we arrive at, kind of give a whole walkthrough
Of that.
statutory ways of concluding that the commercial or advertising would be a violation.
Yeah, I'll look at it.
My suggestion also is that if you're going to essentially initiate a business, which it is, you're renting it out, somebody's renting it out, that they go to the planning office or call up the city
Or
and
permits and licensing.
Permits and licensing.
In all honesty, it wasn't a business. I mean, speak freely, and as far as like what they deal with, and everybody has a great story on that. The bottom line is we took a piece of property that was, the neighbors were condemned, crack course, all this stuff around it. And now we have two pieces of property that the city's gonna get taxed on and putting it into it. We've had hurricane, all the other stuff going on, which caused additional renters. The bottom line is the long term, it's a residence, gonna be mine and my future bride's place to be. But
Yeah, Mr.
again, it doesn't matter. That's all done.
If I can
I'm
say,
just saying
Mr.
that for anyone
Magistrate,
who's listening in who is maybe not adept at looking at city codes and land development regulations, to simply contact the city and see, and try to find out if you can do that there. And
Yeah,
expect you will be routed to the planning office or whoever,
to permits and licensing.
permits and
Yeah.
licensing.
But if I may, Mr. Magistrate, and for you, Mr. Lutens, and I say this regularly when we have our meetings, that there's just by habit, people are not used to calling rental a business, but it is. And so whether it's short-term or long-term, and generally there's going to be permit requirements, and so permit and licensing is the best place to start with any type of rental
Well, we had the permit
venture.
for the, I guess, the long-term or whatever. I think, again, from me, it's my fault and I take ownership, as you can see on that. I'm just trying to say, hey, the way it was a person that I trusted, again, as far as looking in the codes, if he's having a hard time disseminating it, you see where everybody else like me would look at that, and you're true. Like I said, as long as we're in compliant, we're not doing anything illegal, because there's too much of that stuff been going around, and we're trying to clean that up. The last question I have, it was done in, how is this reported? It was reported as a complaint in the
No,
neighborhood?
let me see,
That's-
yours is,
You said a
yes,
citizen's
yes,
complaint.
yes, it was a citizen's complaint, so yes. So if you request that, you can find out who complained, absolutely.
And then I go there. Thank you very much.
Yeah, there's a state law now that provides that those are not confidential anymore.
That's good to know, and it kind of ties into some other stuff, so.
Yeah, and it is accessible on,
Yeah.
it will be accessible on the trackage.
Mm-hmm.
Yeah, so it's
Yeah, if you looked
accessible
up your
on-
case
on
on the
public
website.
I'll
record.
find out now, that's what I was.
Yeah, you can actually pull it up
Yeah.
on going to the codb.us.
And that's the minimum fine as far as the fine that you,
Yes.
Yeah, that's our position always.
okay, thank you.
Thank you. sir.
Therefore, I have to read the order. Therefore, in case number 7, RTL 04-2330, Alan I find the respondents Alan Lutens and Dolores Lutens to have been in noncompliance with Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and a damage surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 255 Lexington Circle. Subsequently come into compliance on April 3rd, 2023. Hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again. And if for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Okay, where do I pay that?
I'll send you an invoice, okay? No, a few days.
Okay, case number 8, RTL 05-2334, Alan Lowen Mihalton and Al C. Mihalton and Kimberly Ashley Burachek, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 168 Boynton Boulevard.
Please state your names.
Alcimi Halton.
And who else is that?
Kimberly Burachek.
Please raise your right hand. Do you solemnly swear or affirm that testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
The case before you is a zoning violation. This case was field generated. The property is zoned MFR 20. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed April 6, 2023, and they were notified the same day. The property was not actively advertising as of April 12, 2023. The daily posted rate was $227. 44 reviews were displayed. The check-in and check-out times were shown as 4 p.m. and 11 a.m. This action is irreparable and irreversible in nature, and due to the actions of the property owner, we're requesting a one-time fine of $1,000.
Okay. Mr. Jackson, do you have anything to add?
Yes, I believe we have on Ms. Mihalton and Ms. Burachek, correct?
Yeah.
I've previously presented the city's position regarding our request for these to be found to be irreversible and irreparable in nature as pursuant to Chapter 16209 of Florida statute. I made that presentation a moment ago, a couple of cases ago. I can make that presentation again for you if you desire. You have the, if you so desire, you can waive me making that again. And if you waive that, we'll just adopt it into this proceeding. Is that something you need me to repeat again, or is that something you're willing to waive?
We can waive because we heard what you were saying.
Okay, well, I don't know if y'all can speak collectively, so each one of y'all, if you're both. But yes, thank you.
Yeah, thank you.
Therefore, I will incorporate Mr. Jackson's presentation regarding the city's position on irreparable and irreversible that was made in case number 6, RTL 04-2326, into this proceeding, into this particular case. Okay. It is your turn now, Ms. Mihalton and Ms. Burachek.
Yes.
Do you have anything to say on your behalf?
Yes, we're just, first and foremost, we want to apologize because we honestly had no idea. We were misinformed. I tried to contact the permits and licensing director through email, and I even have the email here asking if we could do Airbnb, and he never responded. And then we contacted someone from the county named Victoria Benson that for the taxes. She's from the Tax and Treasury Department. Sorry, I dropped my AirPod. I made sure to let her know that it's going to be an Airbnb and if we could do it. And, she said that it would be okay. So we were just misinformed by many people, unfortunately. And yeah, we're sorry. We had no idea.
Yeah, we really would not ever do anything illegal. Honestly, we are not from Florida. We're from Oregon, and we wanted to invest to have a better life for our families. We have little kids, and here is not a good place to invest. It's, as you can see on the internet and the news, that things are going bad here. So we wanted just to, possibly move our family one day. So we wanted to invest somewhere else, somewhere more conservative for raising a family. So honestly, that's why we even did this. So we didn't know that it was, like she said, we were misinformed even after we contacted her that, we can't do it anymore. I forgot, what did she say exactly? Because I don't want to put words to her in the email.
She just said that we were in the right, we're within city limits, and she wasn't sure. She didn't know that we wouldn't be allowed to do a short-term rental. So, yeah.
Ms. Halton, am I?
Yes.
I'm curious. You said you sent an email to who initially?
Glenn, his name was Glenn Urquhart. Urquhart?
Glenn?
I don't.
That's
You
right, Glenn
are-
Urquhart. That's right person.
Earhart.
Okay.
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 Urquhart.
And what is his position?
He is the
It's-
chief building official and head of permits and licensing.
Yeah.
Okay. And what is the date of your
4/4/22 is when I emailed him.
and have you ever received a response from him?
No.
And
don't have
what was the nature of your email? Would you mind reading it?
Not at all. It says, "Hello, my name is Alcime Halton. I am planning on opening a short-term rental in Daytona Beach. We recently purchased a home and we are wanting to get more information on what permits are needed and what is needed in general to get a short-term rental going. I was advised to apply for the DBPR HR 70228 Division of Hotels and Restaurants, which we did and got the permit, but I wanted to contact your office to see if there is anything else that needs to be done. Also, if there are any taxes that need to be paid to the county. Thank you so much for your time."
I feel somewhat chagrined having made my statement before. It appears that they tried to get information, if I understand this correctly, and no one.
In all fairness, there's a lot of things that go on in terms of, and I appreciate that they've gone to the top, but really when we say the division, of course, there's a lot of folks that come before that would have been, wonderful for them to make contact with. A good follow-up, if he didn't respond, probably would have been the best thing to do because it's easy to have things that you pass in email and don't really get back to.
Well,
I don't believe that, in my own position, Mr. Ridgey, I don't believe that should be the answer to someone's, while it's well appreciated that they made those inquiries, it is still clearly in our code and in our law what's permitted and not permitted, and because they started on the front end of research and didn't get an answer, it shouldn't be the basis for saying, okay, they are excused for the actions taken, or that they went and got an incorrect answer from another agency. Understanding they're out of state, may not be even realizing the nature of local government in our state, and that county and doesn't necessarily preempt city on certain issues, and this is one where county would not have the answer to what was necessary for the city. There are
Well,
other
I'm not
divisions in
interested
the
in the
city.
county. We've had a lot of instances where the county has given incorrect information.
As well as
And-
realtors.
And this is a city of Daytona Beach ordinance.
Right.
And so whether or not the county is aware of it or not is sort of, in my feeling, irrelevant.
But it is the city of Daytona Beach ordinance. It's a matter of law. It's already present in law. They want misinformed in the sense that the building official didn't contact them back and say, oh, yes, it's okay. They feel that they ended up with a no answer, which, I don't know the answer for why they didn't get an answer. I don't even know if it was actually received. I presume they say it was. I presume it was. But I don't have any answers to that. But it wouldn't excuse someone from the responsibility of knowing what the law is when they come forward to take action in the city.
I understand, and I know the Florida Supreme Court has said that you are presumed to have knowledge of city ordinances. But that was back in a time when city ordinances were in a book about this big.
But also,
There are now cities that I know of, one just north of here, where even city staff has to do a computer search to figure out what's in their ordinances. They've gotten so complex that humans no longer understand them. You have to, and so I'm kind of the opinion this is a fairly significant fine that is levied against first-time offenders, that when somebody does something and tries to do the right thing and they can't get an answer, that yes, they probably should have waited for an answer, but it would appear to me that, let's see, they sent this on the 4th, but as of today's date, have you received?
Of 22.
Of 22.
Right.
Mm-hmm.
That's when you sent it, at 22?
Yes.
Okay.
And they've
So-
had
so we-
44 reviews on this site.
Well, I understand, but
Which means
a year later, they've still not received.
And they've never re-inquired for a whole year. They've never re-inquired. Mr. Riggio, obviously you get to make whatever decision you like, and I'm okay with that. I'm not trying to tell you not to make decisions that you choose. I'm just saying that the consistency, if we adopt a posture or mindset that says that if someone make a call and they don't get an answer, it's one thing to say I got the wrong answer, but because I didn't get an answer, that's enough to say, okay, excuse me for a year of never doing a follow-up, a year of getting 44 different reviews, and pretty much got the advantage of everything that is contrary to the whole purpose for the ordinance. I just have difficulty with it. I appreciate your position, and I'm not disrespecting it, but I do have a difficulty with taking that as a posture on a repeated basis.
If I could interject real fast, that's okay.
Excuse me?
I said if I could interject.
Please do.
Okay. I just want to mention I did follow up with a phone call 2 times, but I still didn't get a response. And I called. Unfortunately, I don't know their names, and I don't have written like an email, because I did make phone calls to multiple people in the city, but I never got a response. Again, I don't have written proof like I do the email, but I just wanted to put that out there.
And also, we were mistaken. We thought the permits we got was for short-term rental because we actually got the link sent over when we asked. I think it was the county, right? Or
no, it was the city.
So we did. That's the thing. We got a response from someone because we got emailed the permit, and we got but I guess it was for long-term rental.
And we were unaware that it was only for long-term. Sorry.
Sorry.
Are they in the long-term rental program?
Yes, and that's why I think that's why we were mistaken. I guess we didn't realize, we just knew we had a permit, so we didn't know short-term, long-term situation. And I get we take full responsibility. We didn't do our complete research, but I can promise we never even got a speeding ticket. We do follow the law. We are we're not ones to start trouble. We took it down immediately after we saw the sign. We contacted Mr.
Kevin Yates.
Yes, and we apologized and we took it off the short-term rental app and everything. We really were unaware of the situation, and I get it. We should have been more thorough. I don't know what else to say. We're sorry, honestly, and if you want to give us the fine, I mean, we take full responsibility. We just honestly, we didn't. We were totally unaware, and we wouldn't do anything, purposely illegal, if that makes sense.
Okay. Do you have anything further to say?
No.
Okay. All right. I'm trying to balance at this point. Obviously, there is the presumption that you are aware of city ordinances. On the other hand, I'm not sure if those cases were heard today that Supreme Court might go the same route. And I'm looking at this from the standpoint of, on the one hand, the law says you're presumed to know. On the other hand, you tried to find out. So, yes, you are in violation. But as I see it, you tried your very best to not ever get into violation. And so, from my standpoint, I see a fine warranted, but not something significant. And so, I am considering a fine of $100. However, I would really like to, at this point, I'm just operating off of a, what would I call it? The testimony, and you're holding up a piece of paper that you indicate was your email. Do we have anything to corroborate? Does the city have anything or any?
No, and they never shared that information prior to now. That's new information. When we spoke, they never said that.
What I'm really considering doing is continuing this matter so that you can present that as evidence, because I'm making a decision based on something that I really have not seen, and testimony alone can only go so far.
Can we send you the email, or can we forward it?
What I would like to do is, if you could this is a hearing where I am reviewing the evidence that is presented from the city. They're presenting me with evidence, and you, as the party who's been cited, have an obligation to also provide the evidence that supports your defense. And I'm really thinking right now of continuing this matter to give you an opportunity to make that a part of the record so I can see it. And if it's there, and you said you had made 2 phone calls. Now, I don't know if you have any kind of record. I know that in the old days you used to have phone bills. But I know now on phones people save all their under recents, although they get erased typically at some point.
And they can be
Mr. Rizzo,
altered easily.
If I can say this, we don't have any reason to disbelieve if they under sworn testimony saying they made the phone call. So I'm not really looking for proof of the phone calls. If it'll give the magistrate a more comfortable record to have their written document or their email, perhaps it can just be moved to the end of the docket and they can find a way of either forwarding it. If there's an email that it can be sent to, or we can just bring it and put it into the record, that may be a little bit more efficient than saving them for next month.
Okay, that's agreeable. Is that agreeable to you?
Yes. Mm-hmm.
And June, if you can give them where to send it.
Mr. Riggio, we do not have a license under review or granted for the property at 168 at all.
So that's saying there is no rental license there right now.
Yeah.
Correct. We don't have it
Yeah,
under
no.
review, and it's not
I mean, there is a license. I apologize. There is a lot, but it's considered long-term, I guess. That's what the information we got from Mr. Yates over the phone, because we let him know we have the license. And he mentioned that
What does that
this
mean?
is actually considered a long-term, and we weren't aware when we first applied for it.
So,
Okay.
Probably short term, it's probably a short-term state license, but it does not have which would be the next step after
Okay.
APR.
Ms. Mahalton and Ms. Burchek, I don't know how things are in Oregon, but in Florida, we have, I guess the word is plethora of entities that license things. There's the state, which appears you have a license from. There are then county licenses. There are city licenses, and each entity is a kind of little government unto itself. You don't have a license from the city of Daytona Beach. You have a state license, and the city of Daytona Beach, as most cities in Florida do, have licensing programs because the cities tend to be more active in their inspections and things of that nature. So from that standpoint, your license is with the state, and if you are renting that property, you will need to obtain the appropriate license from the city of Daytona Beach.
Yeah, it's vacant. No one's there right now. So that's not an issue. So you're saying we need to get a permit for long-term?
You can obtain a permit, but I think it would probably be best for you to communicate with Mr. Yates, and he can fill you in and make all of that arrangements with you.
Yeah, I'll even be the one inspecting. So,
Mr. Yates, if I'm not mistaken, when we're on the phone that one time, did you not say we had a long-term permit?
No, ma'am. I said that you could long-term rent, but no, I did not inform you that you had a long-term rental.
Oh, okay. Okay.
Okay. So if you could email or send somehow that correspondence that you said you sent to Mr. Earhart, if someone could make contact with them and make that arrangement, then I am willing to reduce the fine. But I need to have something in front of me, I think, to corroborate what has been stated. So
Okay.
if someone can...
You guys have my email? You should.
Is it something that you can actually obtain?
I can
while we're
pop
here?
it up on the iPad right here so we can look at it.
Oh, that's fine, and I can look at
Then
his
we'll
iPad.
And then I can submit it to the record afterwards.
Yeah.
That's fine.
Do you want me to send it right now?
Yes.
Okay, I will do that right now.
Well, we don't even have to continue it then.
Okay.
Simple forward. Okay.
One second, I apologize. Okay. I have it, and I'm forwarding it to Mr. Yates. Oh gosh. Oh, sorry, my computer's. One second. Let me.
You
see
could
if I can do
probably
it
take a
over-
picture of it and send it as an attachment to Mr. Yates's phone.
We could then.
Oh, okay. Is that his cell phone?
No, to my email.
Oh, you have?
Yeah.
Okay.
Okay.
However you want to
You
do
can
it.
email it. I'm pretty sure.
I know I can, but I'm sorry, my email's like being funny. One sec. Let me see. Maybe this will work.
Maybe.
You know, we're wondering if perhaps we could just move it maybe.
Yeah.
Yeah, but what we'd like to do, I'd like to do, Ms. Mahalton and Ms. Burachek, is
Yes.
if you can handle that, we're going to put you aside for a few moments, for a while,
Okay.
and then
Okay.
you can work out the intricacies of the electronics, and then we can put you back on again in maybe 15, 20 minutes.
Okay.
Okay, that's fine.
Thank
All
you,
right.
sir.
So we
Thank
will,
you. I'll be sending that over through my phone. For some reason, my laptop is just not being
okay.
cooperative.
They work when they want.
So we are going to put case number 8 on hold for a few minutes, and we will move on to case number 9. Case number 9, RTL 05-2335, Marissa Gianeri, cite for failure to correct violations of Land Development Code, Article 4, Section 4.1A, Article 5, Section 5.2.A.3 at 1501 Manor Drive. Do we have someone here? Please come forward.
Please state your name. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
All right.
Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned MFR12. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed April 12th, 2023. They were notified the same day. The property was not actively advertising as of April 21st, 2023. The daily posted rate was $173. It displayed 0 reviews. The check-in and check-out time were shown as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson.
No. You're near it. Yep, okay, never mind. I try. I'm Anthony Jackson. I'm an attorney for the city, and I made a prior presentation regarding the city's position and a request for irreparable, for finding that these violations, the nature of the violations, are irreparable and irreversible. The statute says irreparable and irreversible by nature. I've made that presentation. I'd be happy to make it again if you desire me to. If you want to waive that, you're welcome to.
I can waive that.
Okay. Therefore, the city's presentation made by Mr. Jackson on its position regarding these violations being irreparable and irreversible, which was made in case number 6, RTL 04-2326, is hereby incorporated into this matter. Okay. Ms. Giannarini?
Close.
Okay. It's your turn.
Sure. I hate to make the excuse of ignorance because I don't think it's valid. So from what I've learned in this courtroom today, with my actions of not doing my due diligence, that falls on my responsibility. I did, in fact, take it down once I was notified. That is my personal residence. I was in the process of moving to a new location and was planning on putting the property for sale. In the meantime, I did look to see if I could gain a little bit more income. Well, apparently that is not okay. And when I was notified, I did in fact take it down. I did not look into the code. And for that, I kind of accept the responsibility of being unaware and the stance of the city. So
Okay.
It's never been rented. It's vacant and it's for sale right now.
Okay. Well, unfortunately for you, as Mr. Yates has stated, under those circumstances, the city has backed off from its initial position several years ago of all of these violations being $15,000 to reflect that someone took action and remedied things. And so they've asked for $1,000, and that would be what was typically levied on a matters.
Do I
of this
love
nature.
that? No.
No.
But do I think advertising is rentals? No, I don't. And so I do think that that is a little unfair to say that an advertising is the same thing as renting, because I did not, in fact, rent out my home.
Unfortunately, it is, and it's treated the same way. You just didn't get anybody who was apparently interested in your property. And, you know, that, I don't know what to say. That
Sure.
The law,
I accept
legally,
it.
that's the same. So
I accept it.
therefore, I'm going to assess a fine in the amount of $1,000. So therefore, in case number 9, RTL 05-2335, I find the respondent Marissa Giannarini to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 1501 Manor Drive, and who subsequently come into compliance on April 21st, 2023, in hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you.
Okay, thank you.
I'm sorry? I'll send you an invoice.
Thank you so much.
Yeah, well, good luck.
I'm going to move on to case number 10, which is RTL 05-2336, Ivy Nell Estate, and is it Hinsey LLC, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.8.2 at 314 South Franklin Street.
Hey, please state your name.
Anthony Davis. Miss Ivy.
Barbara Ivy.
Please raise your right hands. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth? Okay.
All right. Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed April 14, 2023. They were notified the same day. The property was not actively advertising as of April 27, 2023. The daily posted rate was $145. 12 reviews were displayed. The check-in and check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson.
I've asked anyone representing the group as a whole if there's a necessity. Again, I'm Anthony Jackson, attorney for the city for these matters. I've previously presented to the magistrate. I think y'all were all present when I made my presentation as to the city's position regarding the finding that these are irreparable and irreversible in nature pursuant to Chapter 162 Florida statute. Is there a reason that y'all would want me to, and I would be happy to if you desire, to present that again in this case, or is it something that you would waive a presentation and adopt as part of the case?
We'll wait.
Okay.
Okay.
And of course, you can address any of those issues if you so elect.
All right. Then Mr. Jackson's presentation of the city's position regarding irreparable and irreversible nature of these matters that he made earlier in case number 6, RTL 04-2326, is hereby incorporated into this proceeding. Okay. Who's going to speak for? Mr. Yates, do you have anything further to add?
No, sir.
Okay.
Your Honor, him is Ivy. I'm part of the Ivy Nail Estate. First, Well, I noticed that he said it was field generated. But also, if he was checked to see if field generated, that's also my permanent residence. I receive my mail there. I'm a veteran. I receive all my medicine there. I live there back and forth. We currently have over 7 properties in the city of Daytona Beach between the estate and the family. We're gonna let our nephew talk because when you look at why it's in 2 different names, it's because we're part of the estate, us 3, 2 more, that they're out of town. So that's why we are here. Our nephew here represents a part of the estate that we 3 gave over to the younger 2. So we're letting him represent the younger 2 on the estate. So that's why you see us here together like this.
Okay. Mr. Ivy, and correct me if I'm wrong on this, Mr. Yates, you obtained or found a posting on, was it Airbnb?
Go up to the top. I believe it was Airbnb. Yes, Airbnb.
Okay. And as you've probably heard, as it's been stated before, the advertising alone constitutes, it's called holding out, constitutes the violation. I know you may receive your mail there, but if you're also advertising it as a short-term rental, that is why we're here today.
Well, I'll let my nephew.
Okay. And, sir, do you want to speak to that? Are you sort of the spokesman as to
I
that?
am.
You are. Okay. Please give a presentation.
Again, I am Anthony, and yes, this was advertised out there. We received a notice on April 14th, and on April 14th, everything came down. The original reason for the posting was for me, it was easier for calendar-wise to have my family come and go. Right now, my cousin is staying there with me. This is I live there. So right now, my cousin is staying with me right now. He's finishing up his residency. I'm a doctor. And so as a family property, as an errant property, I share my residence with my family and close friends. So as far as the Airbnb, I could care less. It came down immediately from that posting. I also saw that there's reviews on there. If you look at the reviews, my mother's has a review on there too. It's not shown here, but again, this is family property. These are family and friends. And so I understand what you just stated, that the advertisement in itself is a violation. I accept that. Again, like most people here, we were first offense. I apologize. I could care less about Airbnb. It was really convenient for me. It's all as far as calendar and letting other people schedule when need be. But at this point, I just wanted to make that statement to kind of let you know, like, what the property is actually used for. Like, I live there.
Okay. I have heard others make similar statements, and I'm not criticizing you in any way, but who may have been using it for other means and saying that they have used it for family purposes. The city, as far as I know, has no way of distinguishing who is renting, who is family, who is not. I know a lot of families that have houses and they don't even have to go through Airbnb. They just make the house available to family members. So, but the fine that Mr. Yates has proposed reflects the fact that you responded immediately to his notice to you, and that is the low end of the spectrum from the standpoint of fining, short of some truly, what would you call them, very unusual situations.
I mean, my mom is right here.
Can I talk?
And
Sure.
like I said, she's like on there.
In listening to your presentation this morning, if we contact our friends and we ask for continuance to get affidavits to show that they were friends, because you're saying that you heard this before and this is how you typically handle these situations, and being our first time having to deal with this, if we get affidavits from our friends and family that have stayed that you have posted here on this website as the city's evidence, would that suffice?
We've, at least from my position, I have no way of distinguishing who are family, friends, and things of that nature. And I suspect there are people who out there who everybody would be a family and friend, even if they have never seen them before. And that's a very difficult thing with respect to this. And just, it is the holding out on Airbnb that creates the problem. I don't understand why people, if they have a property and they're sharing it with their family, can't just work it out amongst their family.
What, no, I got this, but, and that you don't understand that, just hear this about our family. We've been coming here to Daytona Beach for a family picnic for over 30 years. Our family has gone to Bethune-Cookman and lived on this property, have gone to Daytona State and Beretto, have lived on this property. These are friends. So if you're going to take us at face value, as I've heard here today, would it not suffice you, sir, if we got this information for you and provided it to you?
Well, I'm not sure that it's going to change
The outcome?
the outcome in any way.
I was going to say, the only thing that we do know from the reviews is that the money did go through Airbnb, so funds were exchanged for stays. So that, unfortunately, in of
I beg to differ.
makes the violation. It's easily look up on Airbnb. That's how the reviews work. So there's no possibility that the money did not go through.
That is absolutely incorrect.
I just don't want to go down the path.
But that is absolutely incorrect. It is up to me to decide whether I charge people or not. And so, yeah, there's a rate out there, but you have to post a rate out there. But I also have to accept the money, and that did not happen.
The problem
can go
comes
in
down
and say-
from you're using what is a rental vehicle
Again,
for family purposes, and the city has no way of knowing, as far as I've been
it
able
won't
to
happen
see so-
again. I assure you it won't happen again. But
Right.
to be honest, to when you say that to me, it's like there's other uses. There's a calendar. It's open to everybody.
Right here, who can leave a review? People who have booked and paid on Airbnb.
Okay, would you show that to that gentleman?
Paid what? They paid Airbnb. That's what I'm saying. Like I didn't receive any money from any of these people.
Well,
And I don't think we're saying we have proof that you received.
Because I
What
didn't.
we're
I don't.
saying is-
There's no proof.
Just so I can clarify, I think what he's saying is, based on the rule, it had to somehow start with Airbnb and someone making payment to him.
But that didn't.
Correct.
Okay,
I understand, you may not have received.
I'm not
the
trying to
email,
defend
but I
Airbnb because
understand.
I don't know what Airbnb has. But yeah, that could be true, but that has nothing to do with me or this estate. Like I put a listing out there. Yes, I did that. It is down. I assure you it will not happen again. I will not use Airbnb again. But again, I want to say that on record, that Airbnb has a calendar available to everyone. It is very convenient if you just want a calendar in and out dates. And so I'm not trying to say that to sway you in any way, but the exchange of money is not happening. I'm not taking money from these people.
Yeah, and just so for clarification, because we're talking specific to Airbnb, but we pretty much, with any of those vacation rental type.
You're making that assumption, and
I'm just saying, using any of them can be the same result, whether it's Airbnb or whether it's a Booking.com, or any of the other ones that are utilized for that. I don't know if it's Booking, but the ones that are utilized for that purpose. So that's for awareness purpose, not because I'm making any assumptions at all. And as far as the advertising, just for information purposes, this is just the basis on why we utilize advertising as part of our review.
And I have learned a lot today. I will definitely say that.
So we're not allowed to have family over during the weekend? Is that what y'all saying also? Because we got a big family.
Yeah, no,
picnic
your
for
people are
30
still.
years.
I'm not
I'll
keeping
be
my
happy to
cousin
speak
out.
to that if I
Mine.
can.
Mr. Jackson.
Yeah. No, absolutely. We're not saying anything about y'all utilizing it for family or anything like that. The primary circumstance that's created this for you guys is because it was advertised on that type of medium, not because of who was there. We don't know who was there. This isn't one where we have people who told us, "Oh, we're short-term renters." This is based on the advertising.
Understood.
And
The
so,
only difference I've heard all day.
Understood.
And sitting here for the first time, what you just stated is the only difference I've heard all day with our situation versus everybody else in here today. Because we can provide the information given the continuous of our family and friends, whereas the others said they could not. or
It's
did
okay.
not.
And then I just want to say, I was just, in.
And because we know you, you can share his mic.
Okay,
Please speak into the microphone.
I was just
Yes,
in St. Simon. I did a review through Airbnb because I have a personal Airbnb account. I didn't have to send any money, but I could do a comment. So that may be something the city wants to look at futuristically, because what you're doing is penalizing your taxpayers and property owners for information that's not given out. I don't care how long the order has been in existence, because in this situation in municipalities, you don't know about it until you're presented with it in writing. So you're doing your citizens a disjustice based on an advertisement, because I just did it and I was in St. Simon.
But that's it. We don't have anything further.
Okay, well. I understand your position, but from my standpoint, once you go on that platform and hold out the property, that is a platform which is intended to hold out properties for short-term rentals. And there's a number of them. And now you may be able to use it for other reasons, but you know, that I don't know, and I'm not going to say that. What I see is that I can't tell that it's not being used as a rental. That's the whole point of that platform. Airbnb does not advertise it. It's a convenient platform for people who want to, you know, share a property amongst their relatives.
But it actually is exactly for that, though, for the record, because I still live there. That's what I'm saying. Like, that is my permanent residence.
You're able to take advantage of something in their system, at least that's what I understand your testimony, allows you to use it in that fashion when it's really intended to set up short-term rentals, and that's what they advertise that they're doing.
So I have a question, just for technical question. Like, do you see the difference between like room sharing and short-term rental? Like, is that this one and the same? Okay.
Okay. Well, I still see this, since it's on the platform that's intended for rentals, and it was taken down quickly, that you were treated the same way as we've treated other people in this situation. And as Mr. Yates has stated, the city is seeking a $1,000 fine. And that resolves the matter. And I would state to anyone who's considering using those platforms for purposes other than what they are intended for, does so at their own risk, because the city's ordinance relates to the holding out for rental, and that is a rental platform. It is not a platform for family reunions or family get-togethers or what have you.
Is that the city's official position? Is that the city's official position?
That is
What
my
you just said?
position. That is my position. Mr. Jackson, would you disagree with that?
No, I mean, I don't know if you all really understood or heard what he was saying there. It's y'all can do whatever you want with your property in terms of utilizing your family and all those things. The platform itself, Airbnb and those types of platforms, are, even if it was your full-time homestead domicile, if you're advertising it or holding it out as a rental, and it's been held out as rental when it has nightly rental rates, it has those types of things. If it's been held out that way, then it's a violation of the code.
Understood.
Okay. Therefore,
So just one other question.
go ahead, please.
Being that fine, that's a set fine of $1,000. Understood that part. Is there an appeal process to that?
The appeal will be the standard appeal for code violations. Chapter 162 provides that, I think it's subsection 11, and that would be within 30 days you can file a appeal with the circuit court.
The circuit court or the city?
With the circuit court.
Okay.
Yeah, it's a this is a final decision of the city as far as the administering an order of
Yeah, we just wanted to know.
fine.
Yeah, and
Administering
I
of fine.
appreciate it. He answered the question fine, and said 1,000. That's fine. So we got 30 days to appeal that process. Is that from today, or is that from when we received a letter?
From the
Rendition of the order, which is the filing of the written order.
Okay, so
What date is that?
so when does that happen? Because we done had this thing been served on the door, it came through the mail, and served by the police department, and served 3 different ways to make sure that we was here today. So I just want to make sure that when y'all send it, you're gonna send it in the mail, right? Once we receive it in the mail, then we have 30 days from the date of receiving it from the mail, or from the date that it's dated on the letter.
it'll be from the date it was dated. However, you're going. Is that something you? How do you normally send out the fine order?
Once Mr. Riggio signs the order,
I sign an order and date it.
and then I'll generate an invoice and mail it to the people.
Okay, so it'll come by mail.
Well, I'll have one. I just want to make sure by state, because it's more than us just making decisions. But what we want to just make sure that we receive it in the time and the manner that our 30 days don't go through.
The appellate rules, obviously I can't advise on the law, but the appellate rules have a provision for matters that are mailed to you. So unless they're date specific, there's time that's allowed to acknowledging or recognizing that it's something that came through the mail.
Thank you.
Okay. Then therefore, in case number 10, RTLO 52336, I find the respondents, Ivy Nell Estate and Hinsey LLC, to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. And such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes for the property at 314 South Franklin Street, and to have subsequently come into compliance on April 27, 2021, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you.
Thank you. All right. Let's move to case number 11, RTLO 52337, Koa Joel Falke and Beatrice Pucci de Carvalho, cited for failure to correct violations of Land Development Code Article 4, Section 4.1a, Article 5, Section 5.2.a.2 at 1146 Pacific Dunes Court.
Please state your name.
Koa Falk.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Okay, Mr. Yates.
The case before you was a zoning violation. This case was field generated. The property is zoned PDG. Other accommodations known as short-term rentals are not allowed in the zoning district. The violation was first observed April 19th, 2023. They were notified the same day. The property was not actively advertising as of May 19th, 2023. The daily posted rate was $131. A total of 24 reviews were displayed. The advertised check-in and checkout time were 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $5,000.
Okay.
And Mr. Jackson, to save you the trip up to the stand, you have a very soothing voice, but I'm okay incorporating what you said earlier into this case.
Okay.
Thank you.
All right.
You looked
Therefore,
comfortable, so.
I'm going to incorporate Mr. Jackson's comments regarding irreparable and irreversible nature of these types of violations as provided for in case number 6 RTL 042326 into this matter. And Mr. Yates, could you just go over the dates again?
It was first observed and he was first notified April 19th, 2023, and it was not taken down until May 19th, 2023.
Okay. All right. Do you have anything further?
No, sir.
Okay, sir, it's your turn.
Good morning and thank you. My name's Koa. I live at the property in question on Pacific Dunes Court with my wife Beatrice. To start, I've never been to anything like this before, so I'm not really sure how it should work other than what I've seen on television and such. With that in mind, I wanted to write down a couple of things so I could adequately express my thoughts and opinions in defense of the situation we are dealing with, if that's okay with everyone. To start off, we've been living in the property for 6 months. It's a new construction home that was finally finished around October of last year. One of the main reasons we chose this home was because it has an attached in-law suite. I don't know if, Your Honor, you're familiar with that kind of house and whatnot. I brought pictures if that'll help, or I'm sure Inspector Yates also has pictures of his own. We live in half and we rent out the other half. There's a door dividing the houses, which is locked off from the interior, and then there's a separate front door. We use this as our primary residency, and it looked like a pretty good fit for a thrifty young couple to try to offset some of our mortgage costs. When we bought the house, we told the sales rep what we were planning on doing, renting out a portion of the home. They certainly made it seem like that wouldn't be any sort of issue. I did a couple of quick internet searches, which seemed to confirm that. I found plenty of homes on the Airbnb website here in Daytona Beach and assumed that would be okay. There was a licensing thing that we did with the state, but as Mr. Yates informed me on the phone, that doesn't necessarily apply here. Even if you Google today, type in, can you Airbnb in Daytona Beach, the first answers come up are general reference to Florida, not specifically to Daytona Beach. We'd experimented previously with a similar home in New Mexico with the Airbnb model, same house with an in-law suite, and we had made more money doing that, so we decided that we'd try to do that down here because there's less wear and tear on the unit versus having standard long-term tenants. Up until about a week ago, we didn't know we were in violation from the city. There was plenty of competition, and the sales rep also indicated that it would more than likely be fine, and we're using that as our primary address. And so I thought the setup was adequate. In reference to the dates that are in discussion, now going to Friday, May 12th, we had some guests hand us a piece of paper that they said was left at their door. That was the piece of paper I brought with me today, the one that says notice of hearing. At first thought, I actually thought it was we watched a lot of those internet shows, and I thought it was a scam of some sort or possibly a prank. And so I think I even asked Mr. Yates in the phone call to provide me with identification to confirm that he indeed worked for the city, and he definitely did. It was on that phone call that we had been notified of the non-compliance issues that had started over a month ago, and that we owed $5,000 in fines, and we needed to take down our listing. For us, this is the first time we'd ever seen or heard of it. I inquired about how this could be. Me and my wife both work from home most of the days, and we had not talked to anyone or received any notices on our door. The only people that normally come knocking are Amazon delivery drivers. He said 2 attempts had been made to contact us directly from home and another via certified mail. The first attempt was made on April 19th. That day we had gone to Disneyland, or Disney World, and we were out of the house all day. When we came home, there wasn't a notice on either of the doors. Perhaps Inspector Yates might have better documentation because my cameras, I wasn't able to pull up any recordings from that far back. But I'm assuming the notice was placed on the rental unit marked with the number 2, and that the guests who were staying there had grabbed the notice, and that it was more than likely left on the table and tossed by the cleaners. We never heard or saw anything about it. The second attempt he said was made on April 21st. We were home that day, at least most of the day. The only time we left the house was to run a few errands. And I wouldn't have any documentation about that day other than the fact that we were expecting a delivery from my wife's work. So I changed the setting on my doorbell camera to let me know when motion was detected. She was being shipped a work phone, and somebody told us that we might need to sign for it. While out, I did get notified that someone triggered the motion setting, and so I sent my wife the clip who was in the store. It was a male woman, and she was talking to the renters in our front unit. We assumed that that was a phone delivery and that we'd missed it. So we stopped by the post office after our errands were done to pick it up. They said it wasn't there. After my wife called her work to inquire about the tracking and figure out what was going on, they told us it was actually shipped to the Walmart store located in southern Daytona because she works for corporate Walmart. Looking back on it, I'm assuming that must have been the second attempt they made to try to contact us. Again, we didn't receive anything from those tenants, and I'm sure if you go and check the delivery, I don't know if you guys have a way of verifying who signed for the package, but it certainly wasn't me or my wife. I'm guessing it was the tenants. On the third reported visit, we were home that day, and checking the recordings, you can see now what I know to be Mr. Inspector Yates going up to the rental unit door and posting something there before leaving. Since it was Friday and already past 5 by the time we received it from the tenants, I figured I would call Monday to try to figure out what was going on. That was the notice of hearing that was mentioned above. On Monday, I called the listed number 3 times to try to contact Mr. Yates. I didn't get a response then. I tried once again on Tuesday and once more again on Wednesday, and I didn't get a response then. On Thursday, that is when we did have our phone conversation, and that I initially referenced. After finding out that he was indeed a real person, not trying to punk me, we took down the listing that very day and tried calling Friday morning again to confirm that it was taken down. I was unable to get that confirmation, but from what Inspector Yates says, everything on his end looks good as of today. I checked everywhere I could. All posting locations seem to have disappeared. And I did bring those videos with me today if that's something you guys would like to see, if it'll help our case, to corroborate the lady coming to the door and Mr. Yates also going to the door, to verify that what I'm actually saying is true and not a fabricated part of the story to seem convenient. To the point, we didn't know or see any form of rent notification alerting us of the violation until 11 days ago. Upon learning the infraction, we reached out at the first opportunity to ensure our compliance, and the listing would have been removed that very Friday had we been able to confirm its authenticity. All written attempts, though to the correct house, were apparently posted or directed to the guests at our residence, to the guest residence, evidently resulting in a delayed alertion. To my knowledge, we were never attempted to be notified by phone, but I'm sure Inspector Yates again could provide any documentation concerning that, because I could very well be mistaken on the matter. For my last point, though not directly related to the already discussed events, but if we are truly levied a fine of $5,000, just simply no way we can afford it. Both of us are recent college grads. Neither of us make that much money as we're both in entry-level positions. In reference to that, COVID was tougher on me than most. I worked in door-to-door sales, which was effectively shut down for 2 years, forcing me to transition. Even though we both worked jobs throughout college and the school year and during the summers, we still have tens of thousands of dollars in student loan debt that we're trying to get in front of. In regards to the house, from the first time we made the initial down payment in February and the time that they allowed us to close on it, since it's a new construction, the price had gone up $50,000 from what we were told. The interest rate doubled. This resulted either in the loss of the house and the down payment, or what we chose by continuing forward with a much higher monthly cost than anticipated. And lastly, we had our first baby the last day of September, right around the time when we were moving into the house and all the research for the rental was being done. The first months did not go without complications for our son. So on top of the normal hospital bills, we are paying the additional visits and expenditures that accompany a situation like that. As of now, we are no longer underwater, but we are effectively living paycheck to paycheck. Now everyone has challenges, and you don't make it far in life relying on excuses, but being where we are here today, I nonetheless understand that we in fact were violating city code guidelines. That's our fault. I should have done more extensive research on what was allowed and not allowed. In my defense, I thought I had done enough research and that we were doing things the right way when we moved. Where we moved from, regulations like this don't exist. Moving forward, we'll continue to work with y'all on whatever needs to be done from a compliance standpoint to make sure that everything stays in good order. My complaint and the reason I showed up today isn't to try to tell you that we're innocent and didn't do anything wrong. I understand that we were in violation of zoning regulations and such actions can result in a fine. I get and understand that it's ultimately our responsibility to make sure we know the rules before jumping into the game. I'm here because I don't feel we were truly given a fair shake. We didn't know. By the time we knew what we were doing wrong, the fine was already at $5,000. I know people probably come in here all day saying that they should be allowed to do what they want. It's their house. There shouldn't be consequences for it. I'm just saying that if we really had been aware of what was going on the first notice, I wouldn't have kept that posting up and risked these even bigger fines with everything else that we already have going on in our hectic lives. Though perhaps you can view this situation from a lens where you guys are technically and legally correct, I would request you to change and look at it from a view that of what's reasonable given the circumstances. Thank you.
Okay.
And again, I do have any videos that you would like to see if to corroborate that part.
I hear what you had to say. Okay. Is there a response from the city?
Just that we did indeed notice, we do have photos of the notice being up on the appropriate dates. And we did everything we could to notice them. I mean, whether or not they complied right away would be outside of our knowledge, you know.
And the statement, and not to attack it or anything, but just to point out, the statement that says it was put on the renter's door, the renter's unit, that was the whole point. It shouldn't be a renter's door or renter's unit in this circumstance. So it was the door, the front door of the units owned by the respondents, and that's the circumstance.
And the other thing that I would point out is that I am legally obligated to post in the most appropriate place. Most appropriate place would be the front door closest to the sidewalk, as to not intrude into his house extra, because any extra is obviously a violation of his search and seizure. So I'm under obligation to post the first front door I get to.
Is that the mother-in-law unit?
I have no idea. I assume that's what he's saying. I just posted it on the first front door I got to.
Yes, sir. It's hard to tell from that picture. I have another one if you would like to see. That unit has a number 2 label on it, and then our front door directly adjacent to it to the right, it has a number 1 on it. And again, I'm not arguing that he didn't post it. That we see that's there. It's, you know.
The posting, is this the first posting?
No, that's the posting for hearing. If you go again, there should be, keep going, there should be, it's not on there. I can certainly.
And Mr. Yates did give me the dates of when they did try to stop by over the phone. Once on the 19th by himself, the 21st by whatever person uses the
No.
mail,
The 21st is when you received the certified mail. I did not stop by again to try to knock on the door just to check.
Correct. I was referencing the 19th is
Yeah, the
is
19th.
when you
and
stopped by the
then,
first time.
May 12th for the notice of hearing, yes.
Yep. And the May 12th one is what I brought with us today, this piece of paper.
You
which
received
is
the
that.
May 12th.
The May 12th, yes. I'm not arguing that point.
Okay. You're going to have to show this to that gentleman. And this, the door that is got a 2 on it.
Yes, sir. That was the unit we were renting out
That's
via
the
Airbnb.
unit, and so that's where,
Correct.
where, Mr. Yates, you said that you posted this on that door on when?
It's 419, you can see it.
Oh, okay, 4/19/2023. Please show it to Mr. Falca.
And this is a single-family residence?
So it's a single-family residence. It's I don't know if you're familiar with the types of homes. They're called mother-in-law suites, depending on the different builders you have. Some call them next-gen or multi-gen homes. The mother-in-law suite is essentially a one-bedroom, one-bath apartment, but it does not have a full-size kitchen, so therefore it classifies and falls under all regulations for the city by a single-family residency. And so, again, we had same thing in New Mexico. We stumbled into a house the same way, and it worked out great for us. So we just try to replicate what we had there here. But apparently, you know, the city has an issue with it, which we are now aware of.
Okay. I just want, I understand your argument, but I just want to be more, have some questions regarding the particulars. Was everything done by posting, or were any actual mailed correspondence sent?
The certified mail was received, but I have not gotten the green card back yet. So the post office has confirmed that it was received, but they have not. Takes a while sometimes for the physical card to come back. But in accordance, that's why he's also posted.
Which one are we talking about when you said the certified mail for which?
The initial notification.
Correct. So on I believe the one you're referring to is the 21st of April, correct?
It would have been somewhere around early April.
Yeah.
mid-April.
So April 19th was Inspector Yates, and then the 21st was the one where I do have that video of we saw a male woman knocking on the guest door, and you can see her handing them things and signing things and whatnot. So again, up until we had the conversation with Inspector Yates, I thought it was just a failed delivery, but apparently that was the notice that the post office apparently was trying to serve us in regards to this matter.
And these were transient tenants, right? I mean, people who were.
Yeah, it's just, I think the people that were there that time, they were only there for 3 days, and I don't think they did anything malicious. More than likely, again, complete assumption that they probably had the notice, left it there for us to find it. We have a neighborhood kid. He's a local junior high. He does our cleaning. You know, he didn't tell us. I'm assuming it just got tossed. I'm not arguing that we shouldn't be fined, because I recognize ultimately, especially after hearing all the other people today, that, yeah, we should be fined, but I don't think the $5,000 fine in our case is particularly fair, indicative of everything that happened. But we'll leave it up to you guys to decide.
Mr. Folke, I don't doubt your sincerity. Okay, so, but what does the city choose to do under these or recommend under these circumstances?
Due to the length that it was up, $5,000 fine.
I will point out my note initially says 15, so that's kind of one point of generosity that came from the city after speaking with this gentleman, I think came from Mr. Yates.
What was the generosity?
Well, my notes initially was 15 from my initial conversation with Mr. Yates, so I'm sure upon hearing the circumstances, he appears to have granted some, at least from the perspective of the city, has granted some relief to make it a recommendation of $5,000.
And for what it's worth on our end, again, every correspondence I had with Inspector Yates, he informed us it's probably going to be a $5,000 fine. So we were, at least all my things I was basing it off of here were what we spoke of over the phone.
We may have spoke prior to your speaking.
We did.
I'm sure you guys do. You get a lot of these from the looks of it.
I'm trying to, again, do the balancing. The fact you didn't receive the notice was because of the acts that were essentially you're being cited for. Your tenants or the person cleaning the room or whatever are taking it upon themselves to perhaps toss things that you should have been aware of.
And we're more than happy to pay a fine. I guess ultimately we're just asking for a reduction to something that is more reasonable or fair in the eyes of everyone here present today.
Your statement is that when you did become aware of it, that you took immediate action.
Correct. And I believe Inspector Yates could corroborate that, where I believe the notice was a Friday, or at this one, the notice of hearing was sent on a Friday, and I do have phone records, or I guess the phone calls of me attempting to contact.
It did go down Thursday, yes.
Monday, and then Tuesday, and then Wednesday, and then the Thursday is when we finally connected, so.
Mr. Yates, in your conversation with Mr. Falke around that time, how did it appear to you as to with respect to?
I mean, he pretty much said it was my fault because we didn't get him the notice. Which is pretty much what we're saying here now.
Okay, but what was your feeling relative to, was this somebody who had just received a notice and was...
I mean, I have a very hard time judging something like that. I really prefer to just stick, sort of with the evidence that I have and just sort of go that direction, because I mean, to make inferences about something like that just goes beyond what I would know.
Okay, well...
And one thing I would like to add too, at the beginning of our call with Mr. Yates, I may have been a little bit more hard-toned. After we got to talking, I realized he's a pretty cool dude. He's not out to get me personally. He's just doing his job. And so at the end of the conversation, I feel like we ended on more level ground. But if I did, come off brash, I
would say
apologize.
based on your sincerity, okay, I can't reduce it too much, okay? The problem is that your argument is, there's that one about the orphan. You have to take pity on me, I'm an orphan because I killed my parents. That is the problem. Your lack of being notified was because of the people who weren't supposed to be there. But again, I'm willing to reduce this to 4,000. I don't know if that helps much, but it's something. I'm willing to do that based solely on the sincerity of what you stated. I believe that you are saying that, but I can't. I mean, there is sort of a presumption that when things are sent that way, that they're coming to you and not being grabbed by people who weren't supposed to be there.
And I would ask if that's the case, if we can only reduce it to $4,000, that perhaps you guys allow some sort of payment plan or extending it past the 30 days, because there's no way I could pay that.
I think Mr. Jackson can explain how a lien fine works, and that may answer your question.
Yeah. It's one of the things, because we do lien reviews on the front end, and people hear us giving time periods for payment. Sometimes people get a little confused about that or concerned. When it comes to fines being imposed on these cases where fines are being imposed, what happens by state law is that those fines are recorded in the public record. And once they're recorded in the public record, they become a lien against the property. And that lien can be there for up to 20 years. And any time in that 20-year time period, you can pay it. So in essence, you really have 20 years. Now, it may accrue interest over time. So to avoid dealing with interest accrual, this is a flat rate. This is not a accruing or a running lien or fine. So it's not one where you have a per diem growth. So it will just be a fixed fine of $4,000. If you pay it within the first 30 days, yeah, generally you won't have any. I don't even know if it'll be recorded if you pay it as soon as you get the invoice. I see so the first 30 days it's not even recorded. So if you pay it in the first 30 days, if you don't have they'll add on like a $24 recording fee once we record it. And then if it's accruing interest, you may have interest as well. And of course, as I said before, you'll have a lien against the property. And what a lien does is it encumbers the property, which will affect your ability to transact utilizing the property, to get loans against the property, to sell it without resolving the lien. Okay.
And then one thing I might try to add then, because again, I work in sales, so I'm trying to figure out the best situation for us. Obviously, the whole situation is we can't afford it. You know, it's going to take a while. I can't anticipate me getting a head start on this thing anytime soon. Is there a way we could delay the filing so then the interest doesn't accrue? Because then I really appreciate the $1,000 off. That's something, but I fear, if I let it sit for a year, I mean, I had a parking ticket one time I forgot about for a week and it tripled, kind of thing. So I don't know how it works in this situation.
Yeah, you'll have to do a little research on that, but I don't believe we, at least from the position of the city, that we have really a mechanism that would be a fair mechanism for making determinations of delay. Maybe Ms. Barnes knows, and I'd be happy to hear from as far as whether the on those fines, if interest is actually accruing. I guess they're running their fixed judgment at that point. Do you have any knowledge to satisfy those with the these satisfactions include accrued interest or not?
They do include interest, but as to an extension, that would be administratively decided by the code compliance manager if he would like to give additional time or something like that.
As far as from filing?
As far as timing and when the interest would actually get added, it would be at the discretion of the code compliance manager.
Okay.
Ms. Barnes, do you happen to know what the interest rate is?
No, but I can look it up.
Okay.
It's the Florida statutory interest rates.
Yeah, for judgments. It's Florida judgment statutory. If you plug it into.
Is that one that varies every
Yeah,
quarter?
varies annually, and it's usually more low than high.
Yeah.
I mean, it's very similar to what you're getting on your it's low. Let's leave it there. So it should not be the biggest worry, although of course every amount is a worry, no doubt. But again, for the sake of consistency, the issue of actually filing it once we have it signed by the magistrate, it's very likely to be filed within after that 30-day time period.
Just for my understanding, then there's nothing that could be done with the delay of filing. But if I were to petition for someone to alleviate interest charges, I would need to go to. There was someone referenced in that conversation. I wasn't quite sure who it was.
Well, the code compliance manager, you could make a request if it's going to take you longer, and he'll review any requests for an extended period. Just tell him how long you need to pay and.
The way it's satisfied is you'll have an invoice or you'll have it on on the record, and you'll need to just pay the city at some point from that invoice. If that's 2 years from now, then that's when you're paying it. But when you do pay it, I think what Ms. Barnes is saying, if there is some issue about interest or something that you want to make an inquiry about, whether or not it's something that we believe meets, we do have a lien process, review process, whether it meets that process requirements, that's unclear. But what I could tell you is that an administrative decision is something that's very possible. So if it's 2 years or 5 years down the road and you had a substantial effect on the interest, at least that's what I'm understanding. I'm not saying that it should be. I'm saying that's what I'm understanding it to be.
Thank you.
But yeah, ideally, the sooner the better in terms of it's whatever you're doing with the property. But if indeed it's your homestead, then you'll have to learn these things on your own through. I can't give you legal advice, but its own effect would be not something you can wait on.
That makes sense. My final request would then be, I came in here with the idea today of asking for it being reduced to $1,000. I don't know if that's really in the ballpark here. I'm very appreciative of what has been given so far. My last request is perhaps we can meet you guys in the middle, $2,500, and then we can at least set aside some money to start that payment plan. I feel like that's a lot more reasonable under the circumstances and something that's easier to stomach for my wife and I.
And I just want to throw something out just because I was researching it and I wanted to look at his certified mail card. The certified mail card does say left with an individual, not signed by the owner or something like that. So that would go towards the possibility that somebody signed for it who was not him.
Well, I mean,
But someone who was at the residence.
If I understand correctly, you're saying that you think that the clock should start running at a later date, that you weren't aware of this until such and such point, and then you quickly took action.
If we could start the fines from when I received this, which was the first one that I physically saw, then it would be $1,000 fine. But again, all the other circumstances here, I maybe shouldn't be treated as the same as everyone else here today, where they got the first notice and they took it down. But according to what I guess Inspector Yates just said, that did confirm at least that one portion of what I said, where it wasn't signed for by my wife and I, and I'm not sure which guest it was. I'm sure I could go back and look it up and match the name to whatever was on that card.
Again, the problem I'm having with this is that the fact that it couldn't be delivered properly was because the people who weren't supposed to be there and the business that's going on were essentially keeping it from being delivered. Maybe not due to your efforts, okay, but your action that we're here before today was in large part due to the fact that you were not getting notified because there were people now in those occupying those properties who weren't supposed to be there, who were interfering with the delivery process.
And I'm not arguing again. I don't think maybe I should be treated with $1,000 fine that I initially had the idea of when coming in today, but I think $2,500 is halfway in the middle, and I, though not stoked for the outcome, would respect that decision and abide by it.
Mr. Jackson.
I believe the position of reduction or acknowledgement of the time issues have been recognized in Mr. Yates' reduction to the $5,000, and I think Mr. Yates' conceit of the circumstance, acknowledging again and accepting the representations of the respondent lets us lean towards the $4,000. I think anything less than that would be solely in the discretion of U.S. Magistrate. It's not something that we would be recommending because of, again, our drive to just be consistent in the way we look at these matters and utilizing what we know and have. And what we know and have is that, indeed, he was in violation, which he acknowledges. The circumstances of delay in notification was self-inflicted by having this event itself. The reasonableness of the posting, it was reasonably posted in the place which should be most noticeable on a unit, and so notice was satisfied and met, and we've given some grace on that, understanding the circumstance in which this respondent is expressed. We understand for some $1,000 is a hardship, and for others $15,000 is a wink for whatever their economic circumstances are. So we don't take light the hardship effect, but the provision of the law does not mandate an immediate payoff, but something that has to be remedied as part of the outcome or the penalties that are being imposed to show, again, the necessity and the seriousness. As we've seen, at least in one circumstance, and maybe even another one for today, where we've had people who, even after being fined a very little amount, has come back with having violated again, because there is an attraction to trying to earn money that balances against us lessening fines and giving a less than substantial acknowledgement of the violation. This is a violation that impacts the community, the neighbors, the neighborhood, as well as the competitive businesses that are lawfully approved for such activity.
Okay.
If I could reference one final point, I did think we were in compliance. Again, I don't know if it carries any weight. I can go back in my email and try to find whatever state documentation I have for, the short-term rentals. We had every intention on short-term renting when we came here, and I felt like we had done that properly, but currently today, I have to do I still need the state one if I were to do it correctly, and the city one, and a county, or?
You cannot do it at that address.
Well, not my home, but if I were to buy one in the tourist zone that you explained to me, do we need all three? Do we need the one?
You just need the BT from us, and then as far as the state goes, that would be you need to be in compliance with them, which is a separate entity.
Yeah, you would have to get with the state to find out what compliance with the state is. If you believe the county has some effect, you got to get with the county to find out their compliance.
It'd be best for him to call the office.
Yeah, the good news is
get the
that
information.
we would only be sanctioning you for violating Daytona Beach. So if you're violating the state, you're probably going to be violating Daytona Beach.
Well, I guess that is a silver lining. Yeah, a lot of entities here.
I said I was willing to drop it to 4,000, and that is it. So I'm ready to issue an order in this matter. And Mr. Folk, you can work out whatever you want to work out with city staff, but for this proceeding, we have to bring this to a close. So therefore, in case number 11, RTL 05-2337, I find the respondents, Koa Joel Folke and Beatrice Pucci de Carvalho, to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. And such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes for the property at 1146 Pacific Dunes Court, subsequently come into compliance on May 19th, 2023, and hereby order the respondent shall pay a fine in the amount of $4,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. Now, Mr. Yates.
Email is indeed.
Email it
Check the email
to
address.
the address we have on file, which is,
Lynn's email. Here it is, as they stated.
we,
Are they still online or whatever?
regular mail and certified mail.
I'm just running out of that.
On opening short-term, we are waiting.
6 Pacific.
We did and got the permit, but I wanted you to contact to see if there's anything else.
Okay.
Okay, can we go back to, oh, they're there.
Okay.
Hello. Hey.
No, this was moved.
Well, I can email.
Oh, yeah, that is.
Yeah, that's moved.
Email you.
Oh, that was my question.
No. They stopped right now.
Okay, all right, that's
Okay.
what I wanted. Okay, good.
You're
All right, continue. I wanted to talk about it, but we don't need to then.
Yeah, 5/16 is their stop date. so.
Okay.
Okay, we are going to go back to case number 8, RTL 05-2334, Ellen Lowen Mahalton and Elsie Mahalton and Kimberly Ashley Burachek.
Got it.
Okay.
Good luck. They'll work.
Ladies, we have received your email. We had some other matters that we've been taking care of in the interim. And yes, you did send an email to Mr. Earhart. And as I said before, my decision based on in that situation is that while you are in violation of the code and you are presumed to have knowledge of the code, you did try your very best, as I see it, to get an answer. And so I had indicated that I was disposed to render a fine against you in the amount of $100. Do you have anything you want to say further?
We just want to say thank you for being so just and just
Generous.
taking in consideration that we really truly didn't mean to do anything like that was against the law, and we're so sorry again. And we thank you for being so lean with us with the fine, and we will never do anything like that again. I can
Okay.
assure you that.
All right. Well, then I have to render the order in this, and that's as follows. In case number 8, RTL 05-2334, I find the respondents Ellen Lowen Mahalton and Elsie Mahalton and Kimberly Ashley Burachek to be in noncompliance, to have been in noncompliance of Article 4, Section 4.18 and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 168 Boynton Boulevard, and it will subsequently come into compliance on April 12th, 2023, and hereby order that respondent shall pay a fine in the amount of $100 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Great,
That's
thank
it.
you. Thank you so much.
All right. And then we have one other matter that's on the agenda.
But we are going to request to continue it to the
Oh,
June hearing due to a medical emergency.
Okay.
Okay. Well, actually, there are two items. I forgot about that one.
He already recognized it. He didn't.
Okay.
I mean, he didn't.
I have been presented with a request for, let me just see where that is. Yeah. Case number 12, RTL 05-2338, Deborah Vincelli and Michael Saviano, who were cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, and Article 5, Section 5.2.8.2 at 484 Gulf Boulevard. And I have been presented with a request for, based on medical considerations, that this matter be continued to June 27th, and that is fine with me. Is that okay with you, Mr. Jackson? Do you
Yeah,
have any
as
objections?
to our best knowledge, they are no longer advertising.
Okay.
But, and with that understanding, we don't have any objection.
Okay. So therefore, I hereby order that case number 12, RTL 05-2338, Deborah Vincelli and Michael Saviano respondents for property at 484 Gulf Boulevard be continued to June 27, 2023. And then there's final miscellaneous business. MB1, SMG 07-19-150, 757 Terrace Avenue, Commonwealth Trust Services, LLC, trustee. They have raised issues or have contacted the city regarding the lien, which is currently on the property in the amount of $12,042.11. And Mr. Jackson?
Yes, well, so what we actually need, Mr. Riggio, is that this case was styled incorrectly, and because of the incorrect case style, we need to correct the case style. We need to correct the order imposing the final lien, and by doing that, it would correct a problem. The problem is that this is actually a land trust, and so as you probably know, with the citing of a land trust, there's a lot more information that goes with this, and I'll present to you the, what we need, but it would be 757 Terrace Avenue Land Trust dated 9/27/2017 is what should have been the style of the case. All of that would be the title of the land trust. Instead, what we had cited was only the portion that said Commonwealth Trust Services, which is the front end. But if we were to look at the deed, the grantee would have been to of course, to the land trust. And because the land trust stands alone on as far as with a parcel, it has since been there's been a conveyance, and it's the land itself is under a whole different name. So we're not trying to eliminate it as relates to the land, but only clarify what would be the continuing lien obligation on the owner, because the reality is once the land trust transfers everything, then it becomes dissolved. Well, it's not dissolved, disassembled, I think it's the terminology they use. So the land trust doesn't exist anymore as an entity, but nevertheless, because it was cited as to the trustee, it continues to encumber the trustee and not the land trust itself.
Okay.
And so our proposal is what I'm presenting to you, which is, as I said, one, we need to modify the And I thought we had a copy. Do you have a copy with you of the deed?
I have a copy of the deed in the
Do you
booklet.
copy the deed in your file?
It should be one in your,
Okay, I didn't,
let me go.
didn't do enough flipping. Okay. Okay, yeah, there it is, warranty deed. Commonwealth Trust Services LLC Trust. As trustee of the 757. So we did the trust was the trustee of the land trust. So the land trust itself was actually the grantee. And that
Okay.
would, and as you can see in the deed, as trustee of 757 Terrace Avenue Land Trust. And so that's what should have been cited as our respondent. As that
Okay.
and so if we'd like to amend the, as I said, the case style as well as the order imposing final lien, and by that amendment, that should, we'll file that as corrected, and that should clean up anyone doing a record search on that property and separate it from, so a correction from Commonwealth Trust Services.
Okay. Has that property still owned by that land trust?
No, it's now owned by Pioneer something. It's another. Yeah, it's now owned by Patriot Properties.
Okay. I have some questions for you.
Okay.
First of all, this was not one of my matters. So, and I see it's a 2019. So that $100 a day has now clearly maxed out over the 15,000.
Yes.
Okay. Now, you would like to change the case style, but that raises an issue of notification to the parties of interest.
Only to the party, I mean, it wouldn't change its effect on the land itself.
No, but for the purposes, this whole proceeding, including the hearings, where the respondent in that was Commonwealth Trust Services, LLC, okay, as acting as trustee.
Okay.
And they are put on notice of this proceeding and can defend and do whatever they need to do. If we change the case style to the 757 Terrace Avenue Land Trust, are they one and the same, or will someone say, I have just discovered that I now have a $15,000 lien against a piece of property that was this a result of a hearing that I was never notified of?
The someone meaning the subsequent purchaser or the 757 trust?
Well, I would I'm looking.
If we're talking about the someone being the 757 trust, that no longer exists. It's disassembled. And that's pursuant to the attorney who represents and handles the trust.
Okay.
I
Now,
have a call to her, but I had not, as far as follow-up, but we had spoken about the circumstance, and their concern is just that what's showing up is encumbering them on everything as the Commonwealth, as the trustee the trustee is the one that's being encumbered, which is, of course, never was the intent. So this is in essence saying that we have an individual, so we're really in essence would have the effect of a partial release of an individual, but by doing it this way, what we're not doing is eliminating the lien as it relates to the land itself. So even a subsequent purchaser, the lien was already was on the land, it was not against the individual. And so they purchased it with that, with it being that situation, that the lien was against the land.
so you feel comfortable in changing what amounts to the respondent in this matter from Commonwealth Trust Services, LLC, to the 757 Terrace Avenue Land Trust?
Yes.
Okay.
And they have no objection expressed to me because we're really transferring it to something that really is already disassembled.
Okay. And this was,
because the
it
nature
sounds to me, their request to you to make this change.
Right. This has been a continual reoccurring effect on them,
and they've been able to get past it at the title company, but they have some underwriters that's not letting it pass right now. And so they're saying this is reoccurring, and if we can end it, because we should have never had the trustee cited in the first place. And I said, yes, that's correct. And so they instructed me that the land trust, once it's sold, and they showed me the statute that says you can't lien the trustee. And okay, by Florida statute, you can't. And as it relates to land trust. And first of all, so we well understood. And secondary, once a land trust attaches as a single entity to a single land parcel. So once the parcel is conveyed or something else happens with the parcel, the trust disassembles. So it no longer has any life. So it's pretty much, we're passing it on to something that's not really living, I guess.
Okay, so really what you're doing is you're correcting perhaps what might be perceived as sort of a title defect by the current owner?
Yes, and and it's a reoccurring effect. And so, I mean, if we did it on just a one-time partial release where we just took this erroneous owner off, it doesn't settle because of the effects of the general lien. The next time someone looks, it'll still be there. So the only way that someone can look and not see it is by us having at least a correction that someone can look and someone doing title work can see, oh, this shouldn't have been them, it should have been this, and this is no longer there.
Okay. So then you just want me to change the case style?
Yes, and
all right.
and amend the lien, because that's what we'd have to follow an amended lien because of its general lien effect. It'll continue to show anytime someone looks on existing lien as it is now.
Okay. So therefore, in case number SMG 07-19-150, I hereby order that the respondent, what are we doing? Technically, we are not amending the case style, but we're actually changing the respondent or amending? Correcting? Okay. Okay, okay. Therefore, in case number SMG 07-19-150, we are correcting the case style to read the City of Daytona Beach versus 757 Terrace Avenue Land Trust dated 9/27/2017, and we are deleting Commonwealth Trust Services LLC trustee as a respondent in that matter.
Yes.
Okay. And also, we are correcting the order imposing fine lien, which is currently located at book 7739, page 4804, Public Records of Volusia County, to read that it is City of Daytona Beach, a Florida Municipal Corporation petitioner, versus 757 Terrace Avenue Land Trust, dated 9/27/217. Is it same address? Or
yes, everything will be the same.
122 East Lake Avenue, Longwood, Florida, 32750. And, and it insert before book recorded on 8/28/19 at book 7739, page 4804. Did you get that?
Yeah, but now I'm thinking it's more amended than corrected because you added things to the order. I was just thinking we were changing the name.
What did he add to the order?
What are we adding to the order?
Well, you're adding the page location, page number, deleting Commonwealth.
Well, the deleting.
Words.
Yeah, the deletion would be still in the line of correction. Now, the addition of the
this is my
Located.
order here,
Yeah.
and it's sort of like a list of corrections that will be taken to revise this particular document.
There'll be a correction. It's just acknowledging, it's locating the correction. So I don't believe
Yeah.
the locating information would make it contrary. Oh, okay. That's a correction. It
Yeah.
should still say correct the deed, and it should still be going in its right place.
Yeah, I want to be certain that that whoever makes the changes changes the correct document. And all these recorded documents in the public records are somewhat unique to book and page number.
Yeah, what we're finding is, and we're looking back, that just to make sure, but we're just trying to make sure, and we're keeping it more in mind now, the need to ensure that we're citing the trust and not the trustees, especially with a land trust. With a general trust, at least you have, I mean, same circumstance, but at least that usually continues in life. But with a land trust, it's specific to date and location and time, and when it's done, it's done. So, so they don't mind. I mean, the issue of when we're over with, and it actually has the effect, as other entities, of ending when it ends, as far as the effects of the general lien.
Okay.
And so that was the expectation, and the fact that it wasn't happening was because of that error in the initial citing.
Okay.
So that's all we need.
All right.
Thank you much. Well, that's actually.
Here's the, I don't need it. No, I don't need that either.
Okay, we'll make them part of the time.
So there's that and.
Yeah, I think I wrote most of it, so I'll confirm that. We'll send it to you before we send it out.
Okay, sounds good.
Is there anything further?
No.
Okay. It being 12:21, I hereby declare that this session of the special magistrate proceeding is adjourned.